I'm delighted to get to be here today, but I thought that we should start, and it would be appropriate to start, since this is after all, a presentation about ethics, to see if I can garner out of you at this early hour of the morning a pledge of honesty, because I'm going to ask you some questions, and so I would like you to tell me, can you be honest when I ask you these next three questions? Can you?
Yeah.
Okay. So by a show of hands, how many people were looking forward to being here all week, as this is the highlight of their week? First test passed. Next question, how many people were looking forward to this somewhere on the spectrum as between a root canal and a colonoscopy? All right, more honesty. And then last but not least, who were just kind of passing by, smelt the coffee, saw the man, I'm out of the office for the day, it's a good deal. All right, well, I kind of figured that would be the case. And, you know, it's an interesting thing. It almost seems oxymoronic to have a lawyer teaching ethics, doesn't it? I mean, you know, let's be honest. But the reality is, it's really, really important to what we do. And it's more important to what you all do, because some of you are underpaid, not paid, volunteers, or barely paid. Others may be in a different situation, but certainly public service is not rewarding on the financial end if it's done right. If it's done right. It is more of and it should be a public service, and we're going to talk a lot about how that fits into the overview of why we're here today. We're going to be touching on three areas over the next 4 hours. And those are ethics, and that's a very broad category, and then sunshine law, and then last, public records. The way the program is set up, we're going to spend 2 hours on ethics, and then an hour on each sunshine law, an hour each on sunshine law and public records. According to the syllabus or handout that you all should have in your package, it says we don't take a break until 10:30 p.m. Everybody good with that? What I actually would like to suggest, if there's no objection, is that we probably should take instead of a 15-minute break at 10:30, which I know is supposed to be a.m., that we take maybe an 8-9 minute break every hour. I think that's probably more appropriate. Is everybody okay with that? Yes, sir. Okay. So let's talk about some things that you all need to know right up front. The first one is this. Of the topics that I could teach, the three topics that I could teach today, the one I'm least comfortable with is ethics, which some of you may find funny. But the reason for that is, even though I am board certified in city, county, and local government law, it is because in almost every case, if I get an ethics question, it is revolving around one issue, and that is, can I vote? So we'll spend some time talking about that, but most of the time, and I'm sure some of your own attorneys have told you the same thing, the best answer to that question, as long as it's asked before the vote, is to call the Florida Commission on Ethics. And that advice is not going to come any different from me today. I certainly know a lot of the rules about that, and we'll be talking about those. But one of the reasons I wanted to start here is because so many of the other things we are also going to talk about, whether it be gifts, working for an agency, and also working for someone who brings business before the agency and things of that nature, are things that I don't have as much personal experience with, because those things are typically and directly referred to the Florida Commission on Ethics for the latest and the greatest. And so we're going to start there today. I'm going to tell you that in every case that I'm answering questions for you about ethics, the best advice I could ever give you, and could ever be given to you by your attorneys, is the following. 1-850-488-7864. That is the number of the Florida Commission on Ethics. I will repeat it because it is not in your materials. 850-488-7864. Am I going to get to be Mike?
Yeah.
Okay. Hello? No, I'm not actually. Not yet. Eventually it'll come on. I have confidence. That office is staffed by some of the most professional attorneys that you will find in terms of providing you the information. Chris Anderson is a personal favorite. I know Verlindia Doss, who is the head of the agency. Many of these people have been doing this for years, focusing literally their entire careers on the issue of ethics under Florida law. And as they will all tell you, they're not there as the police of you, although they certainly assist in that process when they advise the commission that makes ultimate decisions about anybody who has received a complaint and their fate. They are there to help you avoid an issue. One of the things, I was listening to a presentation a little while ago, and it was by Chris Anderson, who some of you, I'm sure, have spoken with. And Chris said at the very beginning that he encourages the kinds of inquiries that happen before the fact because it's so much sadder after. And it's so much sadder because when you've already had the violation, in almost every case, there's no fixing it. And that's really an important thing to take away from what I'm going to tell you today. So if you ask first, you will avoid the problem almost all of the time. And if you don't, it will be almost impossible to save your bacon. That's the reality. Now, there's another tool that I want to tell you about, and particularly now that we have this 4-hour requirement for all municipal elected officials, that they must have ethics training in the combination of the 3 topics that I've told you about: sunshine, public records, and ethics. And that is that if you go to their website, which is www.ethics.state.fl.us, you will find a tab called Training. And in that tab, you will find a number of audio and or video presentations conveniently titled by topic, and most importantly for your 4-hour requirement, by how long it takes to get through them: 55 minutes, 25 minutes, 3 hours, and 10 minutes. And those trainings, according to their website, should qualify for the ethics training requirement. Now you're here, you're going to get your 4 hours today, so why am I telling you this? I suspect that not all of your bodies are here. And they may or may not, it may not be convenient for them to come back to a live presentation. I totally get why live presentations for most people are more preferable to listening to audios and so forth. But in a pinch, and for solid training by the people who do it every day, you can't beat going to their website and looking at these videos and listening to these audios. And so I would commend that space to you. I think it's a great place to go, and I won't be too shy to tell you I've listened to a few of them in preparation for today. When we launch into this topic of ethics, I first want to tell you that I have been advised by Mark that that we may get into some question and answers fairly early on as I get into the substance, and I'm fine with that. You'll find quickly how much I don't know. But I am fine with it because it makes the time go, perhaps keeps everybody engaged, and I maybe I can call on people in the back row that went back there for a reason. Hi guys, I see y'all hiding back there. And so that's really okay with me. But I thought a good place to start, particularly when you're talking about ethics, is some certain things that at one time or another in our life we've heard from a parent, grandparent, uncle, aunt, friend, confidant. And I think those provide a good starting place. One of them is a definition of integrity. And everybody thinks they know what it is, and I've heard many definitions. One of the things that used to tickle me about my dad, he was a trial judge for many years. And he, in the early days of his career, the local bar associations, in his case was Jacksonville Bar, would put out a judicial poll. I'm sure they do this in Volusia County, they do it in Orange County as well, in which judges are ranked in order of various categories by the local bar. Sometimes it's just the defense bar regarding criminal judges, other times it's by the entire bar regarding all the judges. And what he found particularly funny is that they had a category for integrity and a scale of 1 to 10. Obviously it begs the question, what's a 5? I wouldn't begin to tell you, nor would he, but he just thought that with integrity, you either have it or you don't. And so he defined it to me this way, and I commend this definition to you. Integrity is about what you do and what you're willing to do when nobody knows except you. It's the best definition I've ever heard, and I live by it. Now, There are a few other things that I have heard that I think are going to be helpful to you today. One of them, which I used to hear a lot from my mom, was just because so-and-so jumped in the fire doesn't mean you have to jump in after him. Now, as a city attorney, let me tell you why I will tell you this. It is because on more than occasions than I can count, members of the public or people who are interested in a given project, development seems to be a big issue these days in most places I represent, you'll hear someone come to the podium and say, well, why can't we do it like fill in the blank city? Winter Park does it, or, and I'm not picking on Winter Park, I love those guys, or Port Orange does it, or you name it. You'll hear this all the time. In my standard reply, when I hear that, based on a legal question is, where's their lawyer here to tell me how they did that, and if they're willing to stand behind that advice and put their malpractice policy behind it, I'll follow it. But until then, I kind of go with what I know. Well, that becomes important to you here too, because many times I hear as justification, well, I know so-and-so is doing it exactly the same way, but so-and-so's not responsible for you. You're responsible for you. And that's important because your career, your future, your name, your reputation is what's on the line, and it will be no defense to you to say, hey, I know the so-and-so over in this city who was doing it this way, or they went on that trip, or they went to this function, and all those things that made it seem okay to you at the time, they don't really work so good in front of the Commission on Ethics. And last but not least, I think it's important to give you a defensive tool right at the front before we even talk about substance. I think one of the best defenses you have, other than your innate sense of right and wrong, because some of this stuff is not innate. Some of this stuff does require more than a rudimentary knowledge of what seems right and what seems fair. But it is an inquisitive mind. The ability to question why constantly. When I talk to my cities and I talk to my boards, I tell them, when we talk about sunshine and we talk about public records and so forth and so on, that they are literally one vote away from being a hero today and a goat tomorrow. And some of you will know what I'm talking about, right? You get elected on a landslide, and the next thing you know, you decide that a given thing is not appropriate for your jurisdiction, and those same people, how quick can they turn on you? Anybody got a clue on that one? I mean, it's pretty fast. It's like if you blink, you miss it. But it happens. And so your best defense in this regard is an inquisitive mind. And you'll see why that comes into play when we are going through the slide presentation. Now, I don't have it to go to, so I'm going to have to, although I didn't want to, refer to the presentation by looking down here at my iPad, because I can go to the printout where I can see it, where I was going to be able to see it here. I can't see it there, so if you'll bear with me on that. If you have the presentation, the first slide talks about basic principles of ethics in Florida. And it says the following: a public office is a public trust. The people shall have the right to secure and sustain that trust against abuse. That comes straight from Article 2, Section 8 of the Florida Constitution, and it is one of these sections specifically stated by the law requiring you to have this training that we must cover, because it is the underlying foundation of everything that's come since then. If you view your office as a public trust and you understand that term, it should take you a long way down the right road. Let me give you an example that applies in my own business as an attorney. There are a lot of things that attorneys can do and get away with, and that's unfortunate. Frankly, I prefer strong bar rules, and we have them for many things, and some things I wish they were stronger. But one of the things we got a real strong rule on is trust accounting. If you cannot balance your trust account every month to the penny, literally to the penny, you are subject to disbarment. What is a trust account with a lawyer? Well, with a lawyer, it's you give me money for a residential closing. You're going to buy a house. If I spend that money on anything but that closing, if I say, well, I need $5 for lunch today, I'm going to take it, but I'll put it back tomorrow. And even if you do, you are subject to be disbarred. That is how strong that principle of trust is. When you are a trustee for somebody, you have to do everything the right way. There's no excuses, there's no shortcuts, and there's no better way to do it. And so that's how the law views it, and that's what you need to understand. The person who put this physical presentation together is a fellow named John Hubbard. I've never met him. I'm not sure exactly how he would cover these same topics. I put my own spin on it. But the bottom line is I wanted to give him credit where credit is due, because the next thing he said is absolutely true. He says, no man can serve two masters. This is going to go to some core issues we're going to talk about later regarding employment versus your position on an agency. Now, I will say this, because I don't know John, I might suggest that when he wrote that no man can serve two masters, has never had a boss and a wife. But that's a different matter. What are you trying to do here? You're trying to prevent situations which tempt you to dishonor. All right? So what are the basic principles of ethics in Florida? There's a number of them. You'll find almost everything that we're going to cover today on Chapter 112. It is about as exciting as watching paint dry to read it, but there are parts of it that we need to cover. So here it is, Chapter 112, Part 3. That's the Code of Ethics for local government officials. It is essential to the proper conduct and operation of government that public officials be independent and impartial, and that public office not be used for private gain, other than remuneration as provided by law. That means other than whatever small amount of pay you might get for sitting on a city council board, or if you're on an agency like a planning and zoning and get zero, either way, that's all you get. There are some limited exceptions regarding reimbursements for travel and so forth, and we'll talk about some of those things, but the bottom line is that's how you should look at it. If basically anything that's coming before you ends up with money in your pocket, there's a problem, and you need to be fully aware of that. The statute goes on to say that the public interest therefore requires that the law protect against any conflict of interest and establish standards for the conduct of elected officials and government employees in situations where conflicts may exist. It is, next slide, it is declared to be the policy of the state that public officers and employees, state and local, are agents of the people and hold their positions for the benefit of the public. Promoting the public interest and maintaining the respect of the people in their government must be of foremost concern. Well, you'd think, well, can we stop there? Isn't that enough? Don't I get the point? But again, as you will see, as we go through some of these things, there's a little more meat on the bone than just that. So that's where we're going to go. What makes up governmental ethics? Well, first, Chapter 112, and we've talked about that. That's where you'll find almost every restriction and prohibition we're talking about here. It's not all of them, but it's most of them. And then what's called the common law. The common law is case-made law. That's where your peers, some of whom you'll see today and see in the materials, have found out about common law. That's where the judge gets to decide whether you screwed up or not. And I would tell you would like not to be there, and I think that's fairly obvious. And you will see what happens to some folks who have not avoided that situation. And basically, what happens is we get these various statutes, which we're going to talk about today. Then someone claims, well, that didn't really apply to me because, and you will see as we walk you through some of this stuff, that in most of the cases, their thoughts about how they were going to be intelligent and avoid the application of the law to them didn't work out so well. Now, in addition to what's in 112, there are criminal implications beyond those that are in the Code of Ethics, and we should talk about those. First, though, let me talk about some things regarding penalties in Chapter 112. I have never been asked the question, but it seems like to me it would be germane to ask the question, well, what happens if I did something wrong? What is the outcome potentially for me? Well, under the statute, you can be removed from office, you can be censured, you can be fined up to $10,000. You can receive something as little as a letter of guidance. And so there's a wide range of penalties. And a lot about penalties depends on intent and what can be demonstrated and what you knew and what you didn't know and so forth. Well, it occurred to me when I was driving over here today to ask the question that some of you have maybe asked yourselves, which is, why all of a sudden, some of you have been public officials for years, are we now required to have a 4-hour ethics class? Has anybody thought of that before today? I mean, I wonder, what was the motivation behind it? Anybody got any thoughts as to why that might be an issue? Why we might be doing that? Oh, come on, I'm not that scary. Yes, sir.
Well, because of the cell phone and transparency, we have to make some people get make mistakes.
Well, I think that's a good point, and I think that particularly that catching people making mistakes is the point we're going to talk about.
You want to
yes, sir.
repeat what they say?
Yeah, I'm sorry. He said, I apologize, I forgot. I'm not a video guy. But the answer that was given was because we have a lot of electronic communications now, telephones, text messages, that sort of thing, that transparency is significantly important and easier to run into problems with. So that's correct. Yes, sir.
I think we find ourselves in a situation where it's increasingly easy to be accused of a violation. I mean, I understand, for example, that if you fill a balloon with helium and let that go up into the air, that you might be guilty of a felony. So it's so easy to find yourself accused of something even when you perceive that you have done nothing wrong.
The gentleman said that it's because of the times that we're in that the opportunity for being accused is a significant potential factor in why we have this requirement now, and I think that may be also true. It's interesting, though, I have a little bit different spin on it. I think we have a lot more trigger-happy folks out there than we used to. I think people in general, you may disagree, but people in general are much more quick, for reasons that I don't totally grasp, to come into council chambers and excoriate people they've never met, they know nothing about, but they just have a feeling. And that's enough for them to get in front of a mic and broadcast to the world how somebody's on the take, how there's something nasty going on here, and I know y'all probably haven't heard that, but I have. And so I think that's true. But let me suggest to you another more sinister reason. If I hadn't seen it, I really wouldn't be able to say this with a straight face, but I actually did. And that is, by now having you certified that you've had training, there's no I didn't know anymore. There's no I didn't know defense anymore. And that's not insignificant. And let me tell you why it occurred to me to bring this to your attention. In Lake County, one of the cities I represent there is Mount Dora. I went to a sunshine law presentation. That is where I'm most comfortable. Some of you may have seen the DVD I gave on that subject. It's been commercially available for a while. And I talk a lot about my own foibles and how things can go wrong even when you don't expect it or when you've done everything right. But the point is, I go to this presentation, and there's a public records presentation, and there's a sunshine presentation. And one of the speakers was an assistant state attorney who happens to be in that county in charge of enforcement of public records and sunshine law. And the first thing he said when he got to the podium is he said, okay, now who's our moderator? He was not joking. And the moderator raised her hand, and do we have a sign-in sheet for everyone here? He goes, great, I want a copy of it when we're done here, so I'll know that everybody attended this seminar has no excuse when they tell me why they violated the law and didn't understand it, because they're here and they heard it. Now, I'm a cynical guy to some degree because I'm a lawyer, but that mindset concerned me. Not that I really have a problem with it insofar as it goes, but insofar as that I think there is a general perception amongst elected officials that, hey, if I'm a good person, if I do good things in the community, people will see me for what I really am if I make an honest mistake. And I need you to understand, if I don't get anything else through to you today, a lot of what happens to you in one of these situations depends on who's on the other side, and not how you view it, but how they view it. And that's an important thing to kind of keep in the back of your mind. So again, I'm not here to scare you. One of the things that I ultimately probably will do is scare you, but that's not the intent. It is to prepare you, not scare you. Okay, so there are some other issues. Obviously, some of the ethics violations also are criminal. We would obviously not have to talk about bribery without understanding that. Another one is misuse of confidential information. This is a rarity in a time where most things we need to do are in public record or done at open meetings, but there is that possibility, particularly when it involves labor negotiations, which are still protected when cities deal with their police and fire unions most typically, and things of that nature, and information could be misused there, so you need to be careful of it. One of the things that keeps your lawyers awake at night, if they know anything about it, is a more important thing that we're going to talk very little bit about today, but I just want you to be aware of it, and it's called honest services fraud, and that is a federal crime. Now, there's a couple of reasons why I want to talk about it. The first one is that the standard for violation of honest services fraud is incredibly low. As the term would imply, what it means and how it's been interpreted are not exactly the same. It means essentially an honest day's work for an honest day's pay. It can be simplified to those terms. But the question is, what's an honest day's work if you are doing things for the wrong reason? And the federal standard there is very broad. Many folks from South Florida have found themselves caught up in this web. I'm certain it will make its way up here too. It just seems, for whatever reason, whether it's more aggressive federal prosecutors or whatever, there have been a number of issues out of South Florida under this statute. And why it concerns me greatly, it is no bargain to be in the state system, whether it's criminal or ethics, it's no bargain. But there's a significant difference that I don't think the general populace understands. In the federal system, the whole concept of if you happen to face any kind of incarceration, that you might have a time off for good behavior or shortened sentences or anything, that doesn't exist in the federal system. If you get a 5-year sentence in the federal system, you're serving 5. And if you get a 10-year sentence, you're serving 10. That's important, and some public officials in South Florida have learned that the hard way. And some of the things that constitute honest services fraud also constitute a violation of state law. And but for the grace of God go I, if you're charged federally as opposed to through the state laws. So that's something to think about. All right, what is the Commission on Ethics? Well, they are the folks. Yes, sir.
An example of honest services is always better to make something honest or against the law.
Well, I'm glad you asked the question. The question was, what is an example of something that that constitutes honest services fraud? And I brought with me some clippings today, but they will seem very obvious. And so they are not the best examples, and I will tell you what they are. Here's one in which an ex-lobbyist gets house arrest for implicating 2 mayors. He, in front of U.S. District Judge Marcia Cook, a lobbyist named Richard Candia, and I apologize, I'm not trying to call anybody out, but this is public record stuff, was served 4 months of house arrest and 400 hours of community service. And that's not that bad, but when you read why, it's because he turned on 2 different mayors and implicated them, and they went to jail for a while. Now, the reason that's important is what he did there is he was implicated in a scheme along with these particular mayors, one of them being the former mayor of Sweetwater, in a scheme regarding economic development. I see some nods of the heads over here. This is sort of an obvious one. If someone's bringing to you a project in which you know at the end of the day you're going to take home anywhere, but it's been on the article, $40,000 to $60,000, there's probably an issue. I'm going to go out on a limb and say that. So this is an obvious one. But the problem is, and to your point in the back regarding this question of honest services fraud, it really is very broad. And some of the other cases out there have been things that wouldn't necessarily jump off the page at you as fraudulent. Now, I'll give you an example of something that was not charged as honest services fraud, but could have been, and I believe would have ended in an even worse result. Now, this is a current one, and I suspect there's ongoing appeals. I would bet there is, and it's from my home county of Orange County, and it's the Batterson matter. Does anybody not know about the Batterson matter? Scott Batterson was a member of the Orange County Osceola Expressway Authority. And I only know about the allegations, what I read in the paper, which means I may not know a doggone thing. I've learned not to trust the newspaper. However, if the newspaper is to be believed in this situation, what Mr. Batterson is accused of doing, and what he ended up being found guilty of by a jury of his peers, was in talking to a bidder that was coming before them, said that in order to essentially improve their chances of being selected, and that's what I understand, it wasn't a guarantee, it would look better if they had certain additional employees from some other companies that were part of this company. That would strengthen their bid. Now, that concerns me right away, but this is what I do for a living. I can see, and I don't know Mr. Battison from Adam, I could see how someone who's not sensitive to that would not see that as bribery, but that's what he was charged with. And he was convicted of and will now spend the next 7 years of his life explaining to his family while he's away, if he doesn't win his appeal. And so what did he do? Well, he essentially told a bidder, if I understand the facts correctly, told a bidder that if their bid would look better if they could take other companies, which I presume he must have liked some people in these companies, on a friendly basis. There's not been, at least in what I saw published, any direct compensation that ever got back to Mr. Battison. But he was influencing, or trying to influence, according to the testimony as published in the paper, the bidder to bring people on to its staff to strengthen their chance to get the work from the Expressway Authority. So, to your point, could that be honest services fraud? It could be. And those are the kinds of things that concern me, because those don't necessarily jump off the page at you. And so there's a good example. The Commission on Ethics is made up of 9 members. 5 are gubernatorial appointees. What does that mean to you? Well, it means that whatever party's in control and whatever governor's in control, they're generally going to be similar politically, whether they see the world a certain way or not. Can't guarantee that. I don't know any of these people at all, but I mean, you would make that assumption. When the White House is controlled by Democrats, you don't generally see conservative Republicans going on in the Supreme Court, and vice versa. So that's something you can read into whatever you want to read into it. I'm not sure what it means, but I wanted you to understand it.
Cliff?
Yes,
it's
ma'am.
my understanding that they actually have to have members of both parties, although the majority of the 9 members are from the party that's in control in the governor's office, but they do have to have, in this case, it would be 4 Democrats and 5 Republicans.
Okay, so I will repeat that because I don't know how much gets picked up. Ms. Crotty has stated, and I have no reason to quarrel, that it is there has to be some members of both parties within the commission, but the balance or the majority is typically by the party that controls the executive branch. In this case, right now, would be the Republicans. So it would be 4 to 5. The President of the Senate appoints 2, Speaker of House appoints 2, and there are 2 nonpartisans. Their duties include investigating complaints and recommending penalties and advisory opinions. Now, I want to further explain to you, even before we get into more of the details, what kind of things can go wrong. And just like when I talk about sunshine law, the school of hard knocks or personal experience is sometimes the best way to get the point across. One of my cities, who will be nameless, was in a situation where a member of the council, without me knowing it, had literally just prior to the convening of a council meeting, been to a ribbon cutting ceremony. A ribbon cutting ceremony on which he was the architect, because that's what he did. He was an architect. And the business for which he was cutting the ribbon, along with his fellow council members, happened to be on the agenda that night on a different project seeking a variance. I come to the meeting on time. I'm not a ribbon cutter kind of guy. So I show up at the meeting, and the meeting proceeds. We get to the quasi-judicial part of the hearing, which would be the variance. Some of you understand what that means. Does anybody not know what quasi-judicial means versus legislative? I'm happy to explain it. Okay. Yes, sir. Well, quasi-judicial is where your body, whichever it is sitting not as a legislative body making policy in on the grand scheme, like drafting new ordinances regarding what kind of restrictions you want on noise at night and those kinds of things. But quasi-judicials are where you take the existing codes, whatever they may be, look at the applicant and their application for whatever it is, and usually in this case it was a variance, and see whether they meet the criteria or standard based on competent, substantial evidence to get whatever it is they're asking for, in this case a variance. And because it's quasi-judicial, one of the standard procedures, and I'm sure your attorneys do the same, is they tell you, have you had any communication with anybody about this matter? Do you have any conflicts you need to announce? Do you have any documents you've received that you need to put into evidence up front so before we get to this hearing, so your decision will be made based on information that's before the body here and now? All that went forward in this particular proceeding. And the variance was granted. After the variance was granted, because it had been a long meeting, the mayor decided to take a recess and then took me aside and said, Cliff, was there any problem with Bob voting on that variance matter? And I said, I wouldn't know. Why would there be? He goes, well, you know, he was the architect on that project we just did the ribbon cutting for. I said, okay, well, it was the same guy. So it falls under the category of you are there, a principal whom you employed, in this case, the owner of the project for which he was the architect, was now before your body, and you're deciding whether they get or do not get a variance. It was a unanimous variance. That was not the issue. No one had an issue. Had he abstained, the result would have been the same. Unfortunately, that was to no avail before the Commission on Ethics. And after a substantial amount of professional embarrassment, and this guy was as good as they come, he had to pay a $5,000 fine and fall on a sword. Because you can't unvote. You can't. You can't revote. There are no do-overs. And so this is another important concept of ethics, and one of the reasons why I start out with that phone number: ask first, don't try to fix it after the fact. All right. What are the general rules? And I told you about this inquisitive or inquiring mind and why that's important. Here are the things that I would tell you you should ask yourself regarding whether it's a vote, whether it's an unexpected gift or contribution to somebody related to you. Who benefits? Why are they doing it? Is it wrong? Does it tempt me to do something wrong? Not that I would, but could someone else see this as something that would tempt me to do something wrong? Why is this person giving me something? Who is this person? It is amazing to me. Some of you, does anybody here have past experience in the state legislature? If you have never been to Tallahassee on opening day, it's a virtual cornucopia of things that show up: flowers, baskets, all kinds of things. Many have learned not to do that, but I know this because for a time I had a sister who was in the legislature, and she had to basically get a wheelbarrow to send back the stuff that showed up on her desk. These people didn't know her from Adam. She'd just been elected. It happens. And it can happen to you. And it can happen to you unwittingly because they don't necessarily know, whoever they may be, that they're doing anything that causes you an issue, but you have to know. The question then is, can you accept a gift that does not influence you? Well, depends on the gift and where it comes from. And the answer is, just because it influences you or doesn't. I don't ever remember, maybe some of you have heard this before, of any public official saying that they got a gift and ever said, and yes, it influenced me. If anybody has ever heard that, I would like to have that war story in my arsenal, but I don't know of that. So the answer is much simpler than if it does not influence you, because that's not really the standard. A conflict of interest is defined as a situation in which regard for a private interest tends to lead to disregard of a public duty or interest. And so, again, that is not one in which you actually were influenced a certain way. It's objectively, could someone see it that way? And that's really what it boils down to. When we're talking about some of the basic parameters of Florida local government ethics, we are talking about solicitation and acceptance of gifts or bribes, unauthorized compensation, which is a gift for influence, misuse of public position, you're going to see some clips on that, doing business with one's own agency, a conflicting employment or contractual relationship, disclosure or use of certain information that is not to be disclosed, voting conflicts, and restriction on employment of relatives, or we generally call that nepotism. So when we talk about, the first area then we're going to cover in a broad scope is gifts. It is as basic as saying this. No matter what the amount is, literally, no matter what the amount is, 1 cent, $1, $1 million, if when you receive it, you know it is given for the purpose of trying to influence your vote, it is an illegal gift. The statute says, and this is on page, God, the page numbers are blacked out here. 15, 14, 13. I think it's 11.
6 in the handout.
Is it 6 in the handout? Okay. No public officer, employee of an agency, local government attorney, so includes me, or candidate for nomination or election shall solicit anything of value to the recipient, including a gift, loan, reward, promise of future employment, favor, or service, based upon any understanding that the vote, official action, or judgment of the public officer, employee, local government attorney, or candidate would be influenced thereby. Now note the language here, because some of you will clearly be thinking in the back of your minds, wait a minute, I thought there was a $100 limit and a $25 and filing a report and all those things. And we're going to get into that stuff. But here's what you need to understand about what I just read to you. None of those things matter if you know, notwithstanding what you do with it or why you do what you do, that the understanding of the person providing it is to influence your vote. It is illegal, and the amount does not matter. Okay? Now, that puts a serious onus on you to question people's motives. Not just how you see it, but how they see it. Now we talk about unauthorized compensation. No public officer, employee of an agency or local government attorney, or his or her spouse or minor child, shall at any time accept any compensation, payment, or thing of value when such public officer, employee, or local government attorney knows, or with the exercise of reasonable care should know, that it was given to influence a vote or other action in which the officer, employee, or local government attorney was expected to participate in his or her official capacity. Now, I focused on a couple of words here. We put them in bold. One is spouse or minor child. These are sensitive issues. We all love our families, and certainly, I hope for most of us, we love them more than we do public service. In my case, that's clearly that case. And again, I say that with only somewhat of a tongue-in-cheek, because there may not be in this room, but certainly I know people who are addicted to local government almost like a drug. I don't have that problem. But I point this out to you for two reasons. Number one, we all like to think that when our spouses or children have anything come their way, that it's all prodigious and wonderful and the way the stars and the planets lined up. But I would suggest to you that there's a reason that the legislature thought that this would be worthy of putting in here, and therefore me bringing it to your attention. Because you are not allowed to put on blinders. This does not work. And yes, sir.
I have a question on this. How are you dealing with these situations with gifts or monies, whatever, or running for office?
Mm-hmm.
I mean, because everybody that I know, whether they're here or higher up, when they run for office, they get contributions, and that's a gift.
That's one of the exceptions.
But the motives don't change.
That's why it's an exception. We're going to talk about that. The question that I was asked was, what about when you're running for office? We get contributions. We don't know what the motives are for the people making the contribution. And clearly, as someone who only rarely but occasionally has contributed to a campaign, motives in I think many cases are, I like the candidate, I would like to see them succeed, and I may never ever appear before them in my life. And so that clearly is a part of the equation, but there are others, and we know them. I mean, if you followed any campaigns, national or state, you'll see groups from out of state, and you go, well, what's that connection? they have an agenda. The NRA frequently contributes to candidates. They have an agenda. There's no doubt about that. They're wanting to have that person see them in a more favorable light. And that is why, since it's really uncontrollable by the candidate in that regard, they can choose not to accept the donations, but they can't get into why they're being given per se and figure that out. And there's no specific vote in front of them at the time that they're running for office frequently. Sometimes there is in the future, assuming they're reelected, but frequently there's not, and there's no guarantee that they'll get that opportunity again.
And how do you deal with a situation if a company that does work for a city periodically takes every council member and whomever out to dinner during a conference, knowing, I mean, it's very obvious why, but if you know that, where do you go with that?
Well, we're going to get to the category of illegal gifts in a minute, because that could or may not be a legal or illegal gift, and there's some factors we're going to have to get more detail. But let me repeat the question. Actually, I want to make sure I finish both questions. The first is, what about contributions, and where do they fit into that whole idea of knowing that they're trying to influence you and you have to be on your guard? Well, political contributions for a campaign are an exception to the rule, and it's across the board an exception. You don't have to question the motives of why they're given to you. You can, and many candidates do, if they have someone who they believe is objectionable to their own philosophies, will return contributions or reject them, and that happens. But it's not required. The second question was, what happens if, for example, you're at a function, let's say you're at a League of Cities function. I love those. And you are invited by someone who you may know, or a group of people whom you may know to be lobbyists, to a dinner, and they are going to pay the bill. That is a different category of gifts, and we're going to talk about that, because there are certain things that lobbyists and or vendors cannot do, period, or you cannot do with them, and then there's some exceptions to that as well. So all those issues, if I do my job correctly, we're going to get to. But the reason this is such an important part of it is, again, it is hard to tell your child or your spouse that perhaps what has been offered to them might not have been offered for the purest of reasons. But that doesn't excuse you from that responsibility. And that's why this is in here, and why I wanted to, it's important to you to hear this particular part that says that knows, or with the exercise of reasonable discretion or reasonable care, should know that that's why it was done. You know, objectively, without naming names, if one of my child got offered a Fulbright scholarship, I'd be wondering what the heck is going on. And others, maybe not so bad. So, you know, you just have to be honest with yourself about that situation and what's the motivation behind it. Okay, so now we're going to talk about what are reportable gifts and not reportable gifts. First of all, I guess I should talk about some exceptions. Because those are the ones that usually get the most attention. People that have not had a long-term experience with these things don't know. Relatives are an exception, and the definition of relatives is pretty broad. Any gift that's given to you by a relative, with one notable exception, is not reportable, not required to be reported, disclosed, even if it's over $100. So no matter what it is, if it comes from a relative, and again, that definition is very broad, and I'll explain some of the parameters of that in a second, you don't have to report it. The exception is if Uncle Fred happens to be, let's say he is an oil magnate, and he knows that you're on a certain committee that might have influence over drilling in Florida. And all of a sudden, he's decided to up the date of his bequeath to you in the will to today. That's not a relative exception, because no matter how much money, remember what I said, no matter who it comes from, if you know it's designed, or you should know it's designed to influence your vote on an issue, the relative exception will not help you. It will not help you. But in any other case, if Aunt Sue said, I really want you to have the baby grand piano, I didn't play anymore, or whatever, the value notwithstanding, you don't have to report it, and it is not an illegal gift. Now, I told you I'd talk about the definition of relative, because in today's changing family unit, we are doing a better job than we used to a few years of keeping up with what that means. It still does not include boyfriend and girlfriend, but if you are engaged to be married, everyone you hold yourself out as someone who is going to be marrying the other someone, or you are living in the same abode. Even if you're not married, you are a relative under the definition. It used to be, when we talked about relatives, we would talk about spouses and immediate family and so forth, but the definition is much broader than it used to be. Whom can you not accept a gift from? Number one is a political committee of any kind. You can't. And number two is a vendor. And these are all spelled out in chapter 112, 31, 48. What is a reportable gift to you if you're the recipient? A gift from anyone who is not a relative that is over $100 is reportable by you. You can accept a gift from a friend, for example, from an acquaintance, not from a lobbyist if it's over $100, but from any other category that would be non-relative and is not designed to influence your vote, you can accept, but you must report it on the form that's required. I think it's called Form 9. And the timing of the reportation is if you've received it, let's say December 31st of 2014, you must report it on that form by the end of the next quarter. So by March 30th or 31st of 2015, you must report. And so you're reporting in arrears for the prior quarter any gifts that you received that are over that sum. If the gift is under $100, but more than $25, you don't have to report it, but the party who gives it to you, if it's a lobbyist or a vendor, must, and at the time they give it to you, they must tell you that it's going to be reported. So that's another factor. A lot of folks don't realize that the reporting requirement is not just on the public officials, but it's also on the gift givers, and it is, particularly if they fall in the categories of vendors or lobbyists. Always the same principles apply. Whether it's $25, $5, $100, $75. If you know it's done to influence your vote, you can't accept it. Yes, ma'am.
Are you going to get into at some point if your spouse is the recipient of a gift from a vendor or, something like what?
Yes, and in fact, to some degree, that's the question was, what am I going to get into if the gift is to a spouse? And again, it's related to what I said about your children as well. And it does bear repeating, because some of us have wives or spouses that are professional in their own right and deal with folks that would do things on their own right. So that's why the requirement on you as a public official is to make a reasonable effort to determine how this would appear. And some of the factors that go into that is, okay, when we're looking at this gift, let's suppose it's theater tickets. That's one that's common. Well, did they ever get theater tickets or something of like value from this party before you were in office? Did they ever get some sort of special circumstance or treatment in a different way, but of similar value from a same or similar party? And why is that the case? Is it because of something that on a private level they can do and be beneficial to this particular party? And if that's the case, then it doesn't implicate you necessarily. But you aren't required, you aren't allowed to just say, well, that's my wife, or that's my kid. That's where the line is drawn. If objectively I'm looking at it and I can't see the connection between how all of a sudden your wife or your spouse, whatever, your child, is suddenly getting things that wouldn't have seemed to come to them before you took office, it should raise the red flag. I need to ask this question and see if it's legitimate. Okay? Now, when we talk about legal gifts and solicitation and lobbyists and so forth, if you receive gifts from lobbyists, and I use the plural because sometimes lobbyists will pool funds together so that they're under the limit, $15 for a better gift. and then they're not under the $25 threshold, they're not over that, they don't have to report, but pooled together, it would seem a loophole, but it's not for you, because if it's over $100, you have to report it, and if it's from a lobbyist, any value over $100, you have to pay back. So if it's a $150 gift, you'd be responsible for the $50 over the 100, and you must pay that back within 90 days. Okay? Yes, sir.
Your slide here talks about an exception, cannot accept a gift from a political committee or vendor.
Yes, that's a specific statute.
But you're talking about receiving gifts.
Lobbyists.
Lobbyists.
Different. That's a different
and
category.
vendors in contract.
Well-
Can you explain what a political committee is? Are you talking about PACs?
Yes, I'm talking about PACs. I'm sorry?
Is that not a lobbyist?
Not exactly. Here's how the distinction works. First of all, let me ask you a question, put the question on the tape. I was asked, what's the difference between a vendor and a lobbyist? And also, where does that fit in with a political committee? A political committee, starting there, is a political action committee or political action type committee. And they go by various names, you know, and they can cover any range of issues. Some issues which maybe everybody in the room would agree are good causes. But that doesn't mean they aren't political committees. And so the restriction is if it's a political committee, you can't accept a gift from them, and there's no exception to that rule, period. And so if they're formed under state law, which they are, if you know there's a particular statute for how they're formed, they are a political committee, you can't accept gifts, and they shouldn't be given them. You know, that's an interesting point. Now,
Unless it's a campaign contribution.
unless it's a campaign contribution, that's always the exception. Now, if you are in a situation where you're trying to figure out what a lobbyist is, that also has a specific statutory definition. A lobbyist is someone who, for compensation, is trying to influence you to vote a specific way on some issue. And that literally is the definition. Now, this is important because that means that a lot of people that you might not think of as lobbyists could be lobbyists. In my own experience, one of the things that happens frequently is we have coming to our podium for various development projects in various cities, realtors, to advocate for a project. And they can't wait to buttonhole you and take you to lunch and tell you why this project, which they stand a grain of commission on, if it goes through, is a great project. And they don't think of themselves as lobbyists either, but they're there to be compensated, and they're trying desperately to influence your vote. So when they take you to that lunch and say, I got this, it's not Realtor Bill you're dealing with. From a legal standpoint, you're dealing with a lobbyist. And so that's an important thing to understand, because this is one of the things that can get you. Even in my own dealing with these people on a daily basis, you see certain folks on a regular time frame. You know, we have some people that come to every meeting. You might think this is pejorative, but they've been called gadflies. We have others that just show up because they're interested, and you know where they're coming from. They're developer friendly or they're developer unfriendly, whatever the case may be. And if they have the opportunity to buttonhole you or get your ear and explain to you why you did something that you shouldn't have or why you ought to do something else, one of the questions that you need to have running through your mind is anybody paying you for this? Because if they are, you then have to be very cautious about what you can and can't do with that person and what you can and can't accept and who's got responsibility here. So this is one of the key, and we're going to really talk about this a lot in sunshine law because there's so many pitfalls there as well, but that's an important thing for you to understand. Lobbyists, we tend to think of people who are with firms that we can pronounce their name, and you know they say, I'm a lobbyist, and I'm, you know, Marion Hammer with the NRA is a perfect example. If you've ever done with NRA, you've dealt with Marion Hammer. And she is a lobbyist. But a whole lot of other folks that you probably would never think of, don't even know whether they're getting paid or not, probably qualify under the definition.
So you shouldn't let them pay for your cup of coffee?
Didn't say that. If it depends on the circumstances, but if the answer is, as you know it is, to influence your vote on a specific issue, then the answer is you shouldn't let them pay for the cup of coffee. If on the other hand, the issue is to have a discussion to provide some additional information. I mean, this is where the kind of, I told you that some things are not as clear as others. This is where the tension is. Lobbyists shouldn't be a bad word. Frequently, they have information you can't get anywhere else. if you're going to be fair to both whatever they represent and the other side of the argument, whatever the argument may be, having that information is valuable. But I would suggest to you that the safe approach in that situation is buy your own coffee.
So you shouldn't accept a pen from a vendor that has the vendor's name on it.
Again, the answer is, if you're looking for a lawyer to give you the advice, they're going to tell you, yes, you shouldn't. Do I know what levels of absurdity it will go to? I don't think.
That's the issue. It sounds like it goes to levels of absurdity.
It can, and that's the reality. Now again, we talked about the commission. They're the ones who actually issue the advisory opinions. They're the ones who determine at the end of the day whether you should be recommended for sanctions. And do I honestly think that in that circumstance that would happen? I can't cite to an example where it has, but I know what the law says. And the problem with these situations is when you're on the wrong end, what everybody did every other time doesn't matter. And that's really the overriding message here. That's not going to save you. Yes, ma'am.
So basically, there is no free lunch. Like,
That is a great way to summarize where we are right now. And since I promised you a break in an hour, roughly an hour, and we should be about there, why don't we take that now? Because we're about to get into some articles that I think will get your attention. Before we took our break and after, I've been asked the same question by 3 different people, so I assume it's on some people's minds. Apparently there might have been a dinner function last night. Anybody attended? At any rate, here's the synopsis of the question. The question was, well, what if we go to a dinner with, I think in one case it was asking about a forever chocolate fountain or something. It sounded really delicious.
Death by chocolate.
Death by chocolate, that sounded really good to me. Or a dinner in which the sponsoring entity or host happens to be someone with whom, for example, our city has a contract for some service. It will be nameless, but rhymes with
Bargain.
paste sandwichman. At any rate, and where does that leave me on the gift spectrum? Well, again, you have to go back to the basic analysis. The first thing is the dinner designed to influence a vote? And I think that, I would defer to Mr. Anderson on this over at the FCE, but I think their conclusion would be, in a specific way enough to be covered by the statute, the answer is no. There's not specifically anything before you at the moment of this particular thing or coming before you, unless it happens to be you just on the eve of renewal of a franchise. And secondarily, the next question, because if it is, and you perceive it is, then you know the answer is you're not supposed to take it. The second question is, what's its value? And it's hard for me to know exactly what a per person would look like in a dinner like that. I guess it depends on what's on the menu, because, and it also depends on what the function is. For example, I can't ever afford it, but some of you may have been invited to these $1,000 plate political functions, and you know that the dinner's not worth $1,000. It's rubber chicken. But I think typically, and I now know this because I'm proudly in the midst of planning or helping plan, or be more specific, helping pay for my daughter's wedding. I'm really not a planner, I'm a check writer. But in that context, I have seen catering estimates that run anywhere from $21 to $24 per person, which means I think I'm doing pretty good, relatively speaking. And I'm guessing that that's not completely out of line, but I'm guessing here would be attributable to the per person cost of whatever function you might have been at. That would put it under the reportable numbers for the vendor and for you. The only exception being if it was designed to influence your vote and that's how you felt about it. So that's how you deal with that. Now, if it's over 25, they'd have to report it and tell you they're going to, and that should have been a part of the program announcement if it wasn't. And if it's over 100, as I've said, you have to pay the difference back and you have to report it. Yes, ma'am.
So the League of Cities Centers, it's $30 a head, $35.
Again, I'm certainly not going to call out the league, and I don't know, but if they're being paid for by individuals, or are they being sponsored by?
The cities pay that.
Okay, and that's an important thing, because another question I got asked during the break, first of all, the questioner said, well, most of the league dinners are $30 a head, and and that that's paid for by the cities from whence you come. And if that's true, that's a different exception. There's an exception for governmental gifts, things that are provided to you in your service by your own agency to further your service, whether it be your education, your ability to obtain certain benefits for the city. Essentially, you act as a lobbyist or cheerleader for your city. So that's an exception also to the gifts rule when it's coming from your own agency. The example I was asked about is I go to a sponsored dinner sponsored by somebody that happens to be a business that our city works with, and that's a different case. Okay, so those are the questions that I got, and those are the answers I have. I obviously will start where I left off, which is anything more specific to a given situation, your best defense is calling the ethics hotline. Okay, so now where I left you, if you're in the same place I am on, you should be roughly on slide 15, and you'll see what at the beginning of some tales of pitch and woe for folks who have erred in their judgment. And I put these in here not to bury these, or I left these in here. Actually, they were put there by Mr. Hubbard, but I left them in here not to embarrass the people involved. These articles are particularly old. I mentioned some more recent matters, like the Madison matter, and I don't want to shy away from reality, but these are older, 2002 and so forth, and so by now, hopefully, some of this thing is gone. But one of the first things I noticed about this one, which says Basic Principles, Ethics, 3 legislators. And there was a couple. First of all, I was surprised to see Debbie Wasserman Schultz had ever gotten caught up in a situation like this, and she has a national presence now. I'm sure most of you know who she is. But the quote that got my attention was from Representative Addie Green from Mangonia Park, where she said, "I was put up here, and if I get some perks, I deserve those perks." Hey, who's going to argue with that? I mean, seriously. I mean, that's a pretty good logic. And if you think about the stuff y'all have to put up with, I wouldn't say crap, I didn't see people say I would be rude, but the stuff y'all have to put up with, you know, it's kind of understandable she might have that attitude, but unfortunately that does not sit well. But I didn't stop there, because when I read about Ms. Wasserman Schultz and her excuse at the time. She says, and I quote, "I didn't call to ask for the ticket." These are about Disney tickets, by the way. "I didn't call to ask for the tickets because that's illegal. What she did instead, she was merely calling to inquire what special tours and events Disney might be planning on the days of her visit. It was during that call that Disney offered her free tickets for her visit." I can't imagine that call didn't include at some point, "Oh, by the way, I'm Representative Wasserman Schultz." Because I can't, if I call Disney, they're not giving me tickets. I would love it if they would. So I point this out because, again, this becomes a theme through some of the more, the later articles that you'll see. And they go to other aspects, not just gifts, but they also go to misuse of public office. If you go to the next page here, slide 16, this is about a Senator Mandy Dawson. And she actually had come up with a novel idea that she would solicit money to pay for a trip to South Africa from lobbyists. So there's just so much wrong with that, I don't even know where to start. She says, it says, quote, she solicited from 10 lobbyists to pay for a trip for her and a companion to South Africa with other lawmakers, and an investigation has found. And then she says, to her credit, that what she did was wrong and stupid. And if I have one goal today, it is that you leave here without being able to have ever say these words, "I was wrong and stupid." Okay. Now, before we completely get off the whole topic of gifts, there's an important cure provision that doesn't exist to you in other parts of law and ethics, and that is the idea of paying for an improper gift within 90 days of acceptance. It is possible that mistakes can be made. I'll give you an example. I had a police chief, and even though they're not elected officials, they still have the same requirements regarding not accepting any kind of illegal compensation. And he was gifted a very valuable shotgun by someone in the town from whom the agency had a lot of dealings and would have reason to perhaps give better treatment. That was not the intention. These people had gone back for a long period of time, were hunting buddies forever, and so forth and so on. So I clearly understand and understood in that circumstance that this was not an attempt to influence. It was basically guys that had grown up together, one gone one path, one gone another. He was honoring his friend's about to be retirement with this very nice gift. But I had the unfortunate news of telling him that that still was a gift while he was in office, and so he might want to consider rejecting that thing until he was fully retired. And that's where we ended up. He said, well, I don't want to offend him. And I understand that sentiment, I do. But it doesn't change the nature of the outcome. So that's important, and the way to resolve it is to pay the gift within 90 days of acceptance or return it. And there's the amount you pay, because some things are hard to tell. Let me give you some examples. One of the things that you will learn if you listen to any of the tapes on the website is that the definition of gifts may be things that don't jump out at you. The way they define it in the statute is anything for which you didn't pay fair market value is essentially a gift. So let's suppose that you have a friend who has had a place in the mountains forever, and they say, hey, I'm not up there this month, if you guys want to go up there, and this might be something that would happen ordinarily. It might have happened even before you took office. And so you don't even give it a second thought. It is no less a gift because of that circumstance. And it must be reported. It is not an illegal gift, but unless, again, if it was to influence a vote, but it is a gift which, if it's valued at more than $100, which this certainly would be, it needs to be reported. And so that's that kind of thing that can kind of throw you off kilter because, hey, this is what I did before I ever took office. Okay, I understand, but it doesn't matter. And that's really really kind of a fundamental precept of all this stuff. It would be a wonderful world if I could wave a magic wand over all of you and make you know this stuff automatically. Some of it you will, because it'll just feel wrong. But others, things like that, wouldn't necessarily. But you are no less charged with that knowledge. You are supposed to know, and that's really the problem here. That's why I'm here to try to impart some knowledge to you. One of the things that we will not cover, because I can't here today, is the possibility that in your local jurisdictions, you may have ethics provisions that are even stronger than what we're talking about on the state level. And that's perfectly okay. So no matter what I told you today or tell you today about what the state law requires, if you have local ordinances that are more restrictive, you must follow them. And so because there's so many jurisdictions out there, and because each one of them could have their own sets of rules and circumstances that they utilize, it's important for you to understand whether those things exist in your charters, in your codes, or anywhere else. One of the things that I hear more frequently these days, and a couple of my cities are going down this path, one is already there and one is in the process of doing it, is adopting a code of conduct. Have any of y'all had code of conduct type discussions? And the general basis or rule there is things that wouldn't be covered under the code of ethics, but nevertheless create enough of a concern at the agency level, whatever agency it may be or local government may be, that they want to put a restriction on themselves so that those circumstances don't happen. And if they do happen, and in violation of those codes, it's important that you understand not only for whatever local penalties there may be associated with them, but because one of the things that is not understood about the law in Florida as it involves recall of public officials is one of the significant grounds, and there are about 8, is called malfeasance. Malfeasance is defined as the violation of a law. So if you violate a local ordinance that has to do with your ethics, even if you weren't aware of it, that can be the basis of a legally generated recall petition. Again, not a happy place to be. So I wanted to make sure that even though I can't tell you what your local codes may provide, that you make sure you're aware of what they provide. Okay, so that's about as much as I can do on gifts. I hope we got enough of it through to get you the point across that just question things. People wonder why a lot. No public officer, employee of an agency, or local government attorney shall corruptly use, those are well-chosen words, or attempt to use his or her official position, or any property or resource which may be within his or her trust, or perform his or her official duties to secure a special privilege, benefit, or exemption for himself, herself, or others, that you are trying to do a friend or a neighbor a solid is not going to help you here. Now, what kinds of things have we seen? You know, Jim is a fictional Jim who happens to be a city manager. Jim, you know, my buddy lives on so-and-so street, and I know we're not supposed to be out there for another year or two, but they got some bad potholes. Can you get one of those graders out there and solve that problem? Well, Jim, he's working for you guys. He doesn't know what he's going to do. He's trying to stay out of trouble. He doesn't want to get fired, you know, 3 votes of a 5-member council. He's gone. What's he going to do? Well, if he's smart, he's going to tell you, well, we really need to not do that like that. You know, we need to reconsider it in a public meeting and figure out if we need to bump that up the schedule, but this isn't the way to go about it. You've seen, I'm sure you've read headlines about officials who get elected and don't understand, and I don't know why this is the case, but it seems to happen most often with mayors, and I'm not picking on them because I've got one of my mayors sitting right here, but they don't understand the difference between a mayor that is a strong mayor, of which there are only a couple in Central Florida, and a mayor that is a weak or ceremonial mayor, one who just has a vote like everybody else. In a local jurisdiction, which some of you will certainly know I'm talking about, there was a mayor who thought that essentially by having the title mayor, they could run the city. And it's not an uncommon thing, it's happened before. And would use that position to try to accomplish things because from his perspective, he was doing what he was elected to do and get things done. He never saw himself as just one of 5. This is a problem. So, and it says corruptly used or attempt to use. Well, what does that word corrupt? Does that mean, well, he didn't get paid for it? Well, depends on what paid means. If you are benefiting someone who is a friend of yours who then can scratch your back in another way, depending on who's viewing the evidence, that could be corrupt. And so you need to be aware of that and understand that there's a lot of ways to do this. Now, the thing that we see most commonly, and you'll see if you haven't already, some of the articles, is somebody throwing around the weight of their office. To harken back to the prior article with Ms. Wasserman-Schultz, I'm just suspecting that somewhere in that conversation she mentioned who she was. I could be wrong, but I'm guessing. Okay? So I point this out to you because this is just always a bad card to play. You know, we make this joke about celebrities, but somehow we miss it in our own lives. One of my favorite actresses, not because of who she is as a person, I know nothing about her, but it's Reese Witherspoon. She seems to be very versatile. She does a credible Southern accent. She can do a lot of different things, okay? And it also helps that my wife likes to go to movies. So, why do I mention her? Does anybody recall why I mention her? A little episode that happened in Atlanta. Do you know who we are? This is not a good look. It's not a good look for when a celebrity does it, and it's not a good look when you do it. You may think, and in fact, you should be proud of having achieved an elected position. People in wherever you're from express their confidence in you to put you in a chair and make decisions for them. That's a high level of trust. Sometimes it's well-deserved. Sometimes, But at the end of the day, it's never a good look to say, do you know who I am? And it's the best example I can think of misuse of a public office. Now, there are other ways to do it, and one of the first articles is a poor, unfortunate Pete Bato, the former fire chief, who says, and I quote, the mayor, quote, chewed my butt, close quote, because what he was found to have been doing is using a city-owned van to take trips with his firefighter friends over to and it says, play highlight. I'm pretty confident, even though they're in shape guys, they weren't playing highlight. But I'm thinking that they were over there to watch highlight and maybe lay down a bet or two, maybe have a spirit. That is something that not only did he use the equipment in an improper manner, he also never reported those days off, which some might call junkets, as days off or vacation days. And as a result, you know, the Tampa Times had a good time with him. A little further ancient history, and I feel for County Commission Chairwoman Barbara Sheen Todd talks about phone calls. Now, this is almost an obsolete example today because of cell phones and plans and so forth, not relatable to specific calls. But in that day, there was a bunch of calls that she was using on apparently a county-issued phone that were personal in nature, for which the county footed the bill, and she got caught in an unfortunate way, and I'm sure regrets the error. In that whole misuse of public office thing, then there's my own jurisdiction. And by the way, this is a person who I like a great deal. And in terms of him being a friendly guy, he's a very gregarious guy. I don't know anything about his politics. It's funny, for someone who deals with politicians all the time, I stay as far away from politics as you can possibly imagine. I am a registered, unregistered. I'm an independent through and through for one reason. I don't want anybody mad at me. I just want to do my job. And I don't want people to question my motives. But unfortunately, he pulled the "do you know who I am" card when he got pulled over for DUI in Maitland, which happens to be one of my cities. His name is Lee Constantine. And he didn't want to take the test, but what he did want to do is call Kevin Berry. And it says in the article, he's quoted, "I would like to call Kevin Berry first before he would submit to field sobriety or anything else, because he didn't think he was intoxicated." And that's what he's quoted as saying. He unfortunately never got to make that phone call, and he was arrested, and even eventually they worked out a plea deal and so forth. But again, I would submit to you that having been pulled over, done the test, failed or not failed, and then taking his lumps would have been a much better look for him. And I bet you he'd tell you that right now then. "Do you know who I am? And I need to call Kevin Berry." I am confident that he regrets that, ever saying those words. And then last but not least, in terms of the gallery here, speeding ticket wasn't on radar. Now, I found this story interesting because the guy who was doing it was a shopping host on the Home Shopping Channel. I don't ever watch it, so I wouldn't know him. But apparently he thought that was a big deal. But apparently even bigger deal was for him to identify himself as a Bell Bluffs City Commissioner. And he was completely bent out of shape because he was pulled up for speeding, but his radar detector never went off. And so how is it possible that he could be 20 miles over the speed limit without his radar detector going off? And if you read the article, you will know the answer to that is because he wasn't stopped because of radar. You might be shocked to know that they use other methods to detect speed these days, not just radar. One is airplanes, they have the sticks and they do various other methods. VASCAR, which is not a radar base, it's a times, they put a stopwatch and other things. And he was one of those who didn't get the warning, his little beeper didn't go off. And I thought that when I read that, it kind of begged the question. So you were speeding, but your detector didn't tell you, and therefore you couldn't have been speeding. There's a logic there that bit fuzzy. But it's in here primarily because once again, after getting arrested or getting stopped, where he made the biggest error was not in speeding. Any one of us, I might do that on the way back, trying to avoid race traffic today. But what he did is then he set up a meeting to go meet with the city manager, wearing a city commission badge and saying, "We have a problem with your police department." Again, not a good look. Okay. Anybody got any questions on that before we talk about doing business? Yes, sir.
So let me ask you this guy that did the plea bargaining, it occurs to me, does somebody has big bucks that they can pay for, very expensive legal counsel and all that? Do they have the capability to get lesser penalties than the rest of us?
Well, let me just say, first of all, the question is, let me put a finer point on it. Can you get better justice if you have more money? The bar does not want me to answer that question. And it really is beyond the scope of this discussion. But if you want me to take your point that sometimes having more money helps, that would be hard to deny.
What kind of ethics is that?
Well, it's the kind that is determined essentially by being able to hire quality professionals to represent your interests. And it's an interesting point you make because as cities, and I assume most of the cities, there may be some county folks here, but as cities, when we hire consultants, whether they be lawyers or waste management folks or whatever we're hiring, in theory, what we're trying to do is get the most bang for the buck, right? We're trying to do what's best for our citizenry, our constituents, and we're supposed to be crunching the numbers and looking at the services and checking the references and all those things. And there really is very little room, if you do that job the right way, for allowing inappropriate influences to come in. If you've done your homework, it shouldn't be a big deal. And you should want to have those best people. Well, if you think about it in that way, then why would you want an individual not to be able to have the exact same thing? The difference is that individuals don't always have the same resources. This is a fact of life. It's never going to change in this country, and frankly, it's the same in most countries you'll ever see. It's just that way. Would it be wonderful if you could have made wave a magic wand and everybody got access to the same health care, the same lawyers, the same... I mean, this is the debate that's way beyond here, but the reality is that is the system we are in, and if you can afford good help, then you're probably going to get a better result most times. Okay, any questions on misuse of office before we move on? All right. Doing business with one's agency. This is something that I think for most people is an obvious one, but let me go ahead and cover it. Notwithstanding that, no employee of an agency acting in his or her official capacity as a purchasing agent, of which I think there may be at least one here, or public officer acting in his or her official capacity shall either directly or indirectly purchase, rent, or lease any realty, goods, or services for his or her own agency from any business entity of which the officer or employee or the officer's or employee's spouse or child is an officer, partner, director, or proprietor, or in which such officer or employee or the officer's or employee's spouse or child or any combination of them has a material interest. Okay, that's a lot of words. Let me try to parboil it. If your company, your kid's company, your wife's company is bringing to your agency something for your agency to purchase, to utilize, or otherwise engage, there's an issue. And there's an issue that says you cannot act in that situation. You cannot. Now, where it gets crazy, or where it gets difficult for some, and I understand why, is they'll say, well, wait a minute now. You know, I'm a service technician at Bell South or AT&T. And, you know, we have this contract for internet services that's citywide through them as a vendor. It doesn't have any impact on me. Where does that put me? Well, there are opinions that depending on how far away it is that you're removed, that go to that whole issue of materiality, okay? A material interest. And so that frankly is the kind of question I get most often. Many public officials work for larger companies that will on occasion, sometimes it's banks, and then you have a little bit different question. But the bottom line is that can happen. The best answer to any questions in this regard, or where I started with, is it needs to be a case-by-case analysis. If you think you may fall outside of this restriction, you do not want to guess on it. You want to go get an opinion, and you need an official opinion in writing. Now, I haven't said this yet, but I need to. I not only say that to you because it is important for you to get it from the best in the business, and that's who they are. That's what they've devoted their careers to. But it's also important for this legal reason, and that is the opinion that they give you is your defense. One of the things that the Commission on Ethics is very good about, and some people here will know this, is if they have given you an opinion and you still get a complaint lodged against you, even if, as long as you gave them all the facts and you didn't shade the facts, as long as you gave them all the facts, if they then, upon consideration before the entire commission, think, well, I would have done it differently, or I would have said, I think we should have said something differently, they will nevertheless look to what advice you were given through them as indication, A, of your intent, and B, they typically, and I can't say there's no exception, but I'm not aware of a single exception in which they have disregarded that they gave contrary advice and still hammered the public official. Now, this is a world of difference between how the FCE works and how the IRS works. If anybody has ever dealt with the IRS and tax advice, you know exactly what I'm speaking of. They stand behind nothing, but the FCE does. And so that's another reason why that's the place to take that information. What else? Well, again, it depends on what business you're in, but I think this is important to cover, at least in part. I don't want to read the whole thing, but on slide 25, or what's my page 25, nor shall a public officer or employee acting in a private capacity rent, lease, or sell any realty, goods, or services to the officers or employees' own agency. That becomes significant sometimes because you'll have a local developer who has found themselves on P&Z, and they also control a number of buildings in town, and sometimes because of need for expansion, those buildings are just wonderfully placed for the city to say, hey, we need some more space for our rec department. We'd like to go rent from, you. And that's the problem. And so that's why I want to point this out. There are so many individual circumstances that could exist in this room. I could never cover them all, but this is one that comes up enough, because I've seen it in the cities that I represent from time to time, that I thought it was important to point that out too. That is the same thing. And it's important that you be aware of it. One of the things that is covered on slide 26 or page 26 is when we got ethics in Florida. Well, you could argue we should have had ethics from the day we were born and our parents instilled them in us, but as an official matter, October 1st, 1975. And when did the rules regarding ethics apply to you? Some of you will be facing re-election, but you're still in office, and there's no question there. Some of you may be out of office or may be heading into office. Maybe you're candidates now and you're not in office. I don't know that. But once you qualify for elective office, you are now governed by the same rules that the candidate who is already elected is, and until you are no longer a viable candidate for that office, those rules apply to you. If you're appointed to office, as soon as the appointment becomes effective, you are also covered. And if you begin public employment, for example, as a city manager or a city attorney, as soon as you begin that employment, you are equally covered. This becomes an issue, however, and it's particularly interesting, and we'll talk about it in the context of sunshine, because it gets a little crazy. Right now, in fact, in about an hour and a half, qualifying for the Maitland City Council will close. I'm acutely aware of that because there's a lot riding on who's qualifying in this election for mayor. And the significance of it is, over the past 2 or 3 weeks since qualifying began, we've had any number of people announce an intention to run, pick up a packet, and then withdraw. One did it within 24 hours. And the importance of that is, if we were to have a situation, and this has happened, where you start out with a number of candidates, but say on day, a week out from qualifying ending, you're the sole survivor. Everybody else has dropped out. If that has happened, and then when you get to the qualifying date, and nobody else is in, you're the last man standing or last woman standing, but there is not, the official election has not occurred for another 2 or 3 months. As a matter of law, you are deemed elected as soon as qualifying closes and you're the last person standing. And that's important to you to know, because that means that up until then, you could have talked to other members of that body. But as soon as that happens, even before you're sworn into office, you're covered by sunshine. There's only one exception to that, and it's when you are talking to the person who's leaving office. Because the theory is that if they're leaving the seat you're taking, you will never serve at the same time. So you can talk to that person, but you can't talk to anybody else on that body, which you might have otherwise thought was completely fine before you got elected. That's an aspect of sunshine law, but I wanted to cover it here because it fits well into this idea of when did ethics attach to me? And sunshine in this case is a part of that. Now, there is another related principle to this doing business with an agency in terms of conflicting relationships, and here's what it is. No public officer or employee of an agency shall have or hold any employment or contractual relationship with any business entity or any agency which is subject to the regulation of or doing business with an agency of which he or she is an officer or employee, excluding those organizations and their officers who, when acting in their official capacity, enter into or negotiate a collective bargaining contract with the state of any municipality, county, or other political subdivision or of the state. That would be regarding, for example, typically firefighters, police, and so forth. What does that mean? Well, what it means that you could have to make some hard choices. If there is a situation in which your company, and I'm trying to think of a good example on a local level that might be in this category. This is a bad example, but it's the only one I can think of, which probably tells you my mind's in a bad place. But let's suppose you're in the adult entertainment industry, because that's typically regulated locally. And you happen to have gotten elected to a council, but that's your business. Now you have an issue, because that business is now regulated by the same body you're on based on local ordinance. You would have an issue. And I wish I could have come up with a better example, but that's the one I can think of immediately that comes to mind. I'm sure there are many others, but that's one of an example. In addition, and this is where you're more likely to have an issue, if you have or hold any employment or contractual relationship that will create a continuing or frequently recurring conflict between his or her private interests and the performance of his or her public duties that would impede the full and faithful discharge of his or her public duties. Now that's a lot of words too, but here's what it boils down to. I get often, it's funny, I think that the public at large would be surprised at how often I get asked about conflicts that don't exist, where the people really have no reason not to vote, but true to what I think is the standard that it should be, it didn't feel right. So they at least asked the question. They wanted to be sure that there was nothing there. This recently happened, for example, in a case where we were asked to get a formal opinion for a member of our planning and zoning board in one of my cities. And he's a real estate developer. He's been wildly successful, made a bunch of money, and the city is going through redoing its downtown, or trying to redo its downtown. And one of the projects that was just recently approved involved the provision by which the city said to the developer that any city parking spaces could be utilized by that developer as long as the city had them for overflow parking. And further, that if the city, that would be something the city would always make available, whatever the spaces were that the city had in the off hours, meaning after 5 o'clock, the vendor or the developer would be able to use for his project right across the street for overflow, for restaurants and that sort of thing. A related project, very close by to this one I'm talking about, which was approved, was on the agenda to be considered, and it included an additional parking element for the city. In theory, the concern of this particular member was, well, if I am now considering this second project, which includes parking for the city, that will benefit this other development. This other development, he had disqualified himself in because he had an ownership interest in. So if I look at the second development and I go down the road and I say, well, let's approve that, then I'm providing additional parking through the city to the first development. Is that a conflict? So, and I was fairly confident in my answer that it was not a conflict, which may surprise some of you. But the reality is that's such a remote possibility in time. We requested and got a formal opinion. We received it, in fact, I think the day before yesterday. And that was such a remote conflict as to not provide one. And the reason that's significant to you is because there is a corollary to the don't vote if you have a conflict rule. And that is, unless you have a conflict, you have to vote. And I'm going to show you that statute. Why is this important? And how does that relate to what I just told you about frequently recurring conflicts? Many times people, for various reasons, just don't want to weigh in. They maybe popularity, they just want to get in the middle of a divisive issue, whatever the situation may be. If you constantly are clearing conflicts, and they're real conflicts, because you really do have an issue, you have a bigger issue. And you're not supposed to be in public office unless you can actually exercise the duties of that office, one of which is to vote, unless you have a conflict. What that means, and you see the line here, it says that may yield a harsh result in a choice between public office and private employment. And I agree that that may be a harsh result, but it's also the result that's required. What are exceptions to doing business with one's own agency? Is anybody here, instead of being an elected official, an appointed board member, like a planning and zoning or something like that? Wow, okay. Well, I will tell you this because even as elected officials, you should know about this exception. You might have in one of your cities a advisory board member, somebody on a P&Z or a code enforcement or something along that, some advisory level board in your city. And they might have a conflict based on any of those rules we just talked about. But under the statute, if it's an advisory board, you can, if they fully disclose the conflict, by 2/3 vote of the appointing body, meaning you appointed them, you can waive that conflict if you believe it's in your interest and theirs to do so. So that's an exception, but it's only applicable to advisory boards. It can only be done not by the board itself, but by the appointing board, the board that put them there to start with. Here's some other exemptions. If you are in a situation where there is a limited pool of vendors, let's suppose it is a certain type of contractor that does a certain kind of very specialized work, and there's only 5 or 6 of them in your whole community. So you put them on a rotation system so that every 5th one, your agency, your employer is going to come up, but that's just, it's the rotational system. There's no choice involved. That's an exception to the doing business with one's own agency. If, under certain criteria, if you go through a competitive bid process and you obviously you would have to abstain from voting and all the things that go along with it, that is an exception as well. If we're talking about advertising on a common carrier, utility services and so forth, those are exceptions. And sole source. Some of you clearly must be familiar with sole source, where certainly in smaller communities, this is the only party who does whatever this thing is. So those are some examples. Now I'm going to quickly cover, I'm looking at my watch and trying to figure out how I get to sunshine in time, so I want to go through some of these quicker. The disclosure of use of certain information, basically it'd be like, the view of this is like insider trading. If you have information that you got confidentially, not through public records, not through public meetings, but confidentially. Example, have any of you been in a shade meeting? Do you know what a shade meeting is? You're sitting in a meeting with your attorney behind closed doors. It's one of the limit exceptions based on ongoing litigation in a case against, it has to be ongoing litigation in a case against your government. It's supposed to be talking about settlement discussions and litigation-related expenditures to those things. But let's suppose in the context of one of those shade meetings, you learn something that you could take a competitive advantage of in the marketplace because it happens the party that's suing the city may be one of your competitors. And so you know, for example, based on whatever the issue is, that they're considering another development in a different location, and if you get over there and buy that property, that's going to be good for you and bad for them, but you learned it in a confidential meeting. That's an example of violating this law. And so it can happen in different ways. Another one is, have any of you sat in on collective bargaining closed meetings where you have to negotiate with the fire union or the police union? If you have, all of those proceedings under statute are confidential. I don't know the context of information you might get there that you could utilize to your advantage, because frankly, people who have bad intent are way more creative than me, because they think of things to do that are wrong that I never even would have known. But bottom line is, if it feels wrong, it is, and if you're using confidentially obtained information to get a benefit, you can't do it. All right, I want to spend most of the rest of the time on voting conflicts, and the reason I do is because that's the thing, as I started off, where I hear the most issue. Now I told you, and I'm jumping ahead, and I'll tell you the slide just so you can see it, and because it's going to override everything else I tell you. And it's slide number 35 or page 35 in the handout. It says you must vote unless you have a conflict, and it's the cite to the statute 286.012. And that's important because, as I say, it will be the undercurrent of everything else I tell you about conflicts. And what it says is no member of any state, county, or municipal governmental board, commission, or agency who is present at any meeting of any such body at which an official decision, ruling, or other official act is to be taken or adopted may abstain from voting in regard to any such decision, ruling, or act. And a vote shall be recorded or counted for each such member present, except when with respect to any such member there is or appears to be a possible conflict. So I told you there is a requirement that many of you may not have been aware of, that you don't have an option not to vote if you do not have a conflict. It's not a convenient way of avoiding or making a political dodge. It's not. At the same time, and in the same breath, it's like a lawyer saying, and on the other hand, it also adds language which can save you if there's uncertainty. When it or appears to be a possible conflict. And this was pointed out to me by Mr. Anderson at the Commission on Ethics, because sometimes things come up that you didn't foresee. Even though you've got an agenda, something has come up, things have gone a little bit off course. I know that never happens in our meetings, but I think it may happen in some of yours. And if it does, now you're like, I'm on the spot, I haven't had a chance to call a commission on ethics, I haven't had a chance to get with the city attorney, what do I do? This is your safe zone. But again, it should not be used willy-nilly. It needs to be used when there really does appear to be a possible conflict and you haven't had a chance to check it out. And then and only then are you not allowed to not vote or abstain. So now what are conflicts? This is an interesting thing where the law has changed recently. I used to be able to talk about this very quickly. If the vote that you are going to make inures to your special, private gain or loss, you have a conflict. But much like sunshine law, the devil's in the details. What does that mean? What does that mean? And that is a confusing thing, which has only gotten a little less confusing. Because when you think about it, particularly when people hear those words, they go, well, wait a minute, I get the gain part, but what about the loss part? Well, if I was a tax guy, I could explain why losses are a good thing for some people, but they are. And that's what part of this is an attempt to capture, because things that seem like a loss in one regard can be a gain in another. And that's why this is designed to avoid all kind of evasive devices. But then the words that become important and become the focus are special and private. So let me give you some examples of not special and private and with what are special and private. Real life example. Mayor, kids are in a private school. Private school is before the city in order to attain a PD to expand their campus and add facilities. It is a decision that has to be voted on by the council, of which he happens to be the mayor. His kids are one of, or two of probably 300 kids. Is that a special private gain or loss on which he has a conflict? Anybody got a guess? Good thought. That's right. Although he was scared to death. And in fact, until I got him the opinion, he didn't believe it. And the reason is because the percentage of potential benefit, first of all, it's a benefit shared by everybody who goes to that school if the thing is approved. Second of all, it was arguable as to whether it was a benefit because with the increased size of campus, what does that mean increases? Tuition, buddy. I paid a lot of that. And so there's that too. And then last but not least, it was a decision that impacted not just the people who went there, but the entirety of the community. So in that case, something that he was concerned about turned out to be not an issue. I'm going to give you two examples that are identical to one another, say one fact, and then you tell me how that comes out. I'm in a homeowners association, small homeowners association, 125 homes. I'm just a member of the city council. And something is come before my body. Let's suppose it is a decision on whether to repave the street within the community at this time or at some future time. And that is now before me for a vote. Do I have a conflict? 125 homes, my community, that's where I live. I'm on the body. Vote before me. Do I have a conflict? Yes or no? Anybody? What? The answer I'm hearing is no. Sir, why not? Why do I not have a conflict?
Well, because it's below the 1% class test.
See, now there's the A student right there. Yes, we now have something to look at. And if you'll look in your materials, we talked about the size of the class. If I ask the exact same question and you're in a 25 home subdivision, the answer's you have a conflict. And so this is really one of those areas where you go, wait a minute, it really does matter how many houses? Yeah, it really does. And that's where the law is broken down because they have trouble figuring out how to draw that line between special and private and basically benefits that are in a larger enough category or your benefits are diluted enough that that you don't have a conflict. And so that's where they've drawn the line. They've drawn the line at the 1% test. And whether if it's remote or speculative, we've talked about some of those things as well. But that's really it. But there's been a little additional thing that's been added recently because one of the the Ethics Commission will be careful to tell you this, that they do not yet know what this new change means. But one of the things that's been added to the statute is there is a provision now that the benefit needs a monetary component. Whether or not that is how the Commission on Ethics, when it starts rendering its opinions, will actually see that will be on a case-by-case basis, and we don't know yet. But that's an interesting thing so, in terms of that, because if that were the case, if that's really where it comes down, if the statute means what it appears to mean, then a lot of things that would have created conflicts before may not now. What is the advice I'm giving you today? I'm giving you today the same advice I would have given you before they passed the statute, because until there's an opinion that tells specifically to the contrary, I think you need to assume that if in any way someone could view what is being done for you as a special private gain or loss, regardless of whether it's monetary or not, you should consider that a special private gain or loss for the purpose of conflict. And if you have any doubt about it, you know the number. Pick up the phone.
What if they offer us tickets to Disney?
Oh, are they over $100? I was asked, what happens if they offered tickets to Disney? Listen, I would pay somebody $100 just to stand in line to get the tickets, but that's a different issue. Okay, I think I really maybe should spend about 2 or 3 minutes on nepotism, only because there's an exception that I think will probably apply to some of the communities out here. I don't need to explain to you that you don't get to hire your relatives, your wives, your sons, your daughters, your aunts, your uncles. That is something that is so basic that you didn't need me to tell you that. However, something that I only learned recently as a part of preparing for this is that there is an exception if you're in a jurisdiction where the population is under 35,000, and if the board that you are looking for or employ, or the person you're employing is not going to be in any capacity involving land planning or zoning responsibilities. So they couldn't serve on P&Z, they couldn't be in your community development department or your zoning. But if you're in a population of under 35,000 and you're not involved in any land planning function like code enforcement, Board of Adjustment Appeals, land planning agency, planning commission, so forth, then you have an ability to violate what would otherwise be the no employment rule, and that's based on population. So that's it. Now, I think we've arrived at our second break point. I think we can probably go till, I'm supposed to finish at 11:30, am I not?
12:30.
12:30? Okay, and I'm looking at it, so I'll get there. We'll get it done. But let's take a break until 11 straight up, and then I'll go to public records and such. Let me talk to you about what is my favorite topic, and also use this moment as a personal moment to complain. Some of you will know that I did a DVD on this topic about 4 or 5 years ago, and unfortunately not enough of y'all bought it, or I would have retired. And if you still have to look at it, that is your punishment for not buying any more of them. And so there you go. It is not still available, unfortunately, but it is out there in the blogosphere, and you can find a copy of it. And I think I have 3 or 4 left if anybody really wants to be bored to death. But it does, in about 30 minutes, what I'm going to spend the next hour and a half on, because that's what lawyers do. Here's the critical thing that you need to understand about sunshine law. It was written by a bunch of lawyers. It's not very long, and yet it could fill a room of volumes in terms of how it's been interpreted. It literally, the significance of it is about a paragraph. But the cases that have been dealt with about it, the lives that it has screwed up, and some of them ruined, are legion. And therefore, it is my wheelhouse when it comes to trying to keep my folks out of trouble. Because even though I spent the last 2 hours, because I was required to, and then some, to talk about ethics, that's where we have the least issue most of the time. Because almost everything that I told you, and is evidenced by the fact that the folks in here in the room are here and not in jail, they generally don't have a problem missing that one. So, but the sunshine's a little bit different. First, let me start with this sobering bit of information. I've been doing law in this area for about 16 years. I've been doing law as a career for 30. I started in doing nothing but complex litigation and actually backed my way into city law because I was a good litigator and won cases. Some of you who are familiar with what's going on in Ponce Inlet might have a question about that. But I can tell you I do win cases, and that one I hope will ultimately come out the right way too. And so I got hired to litigate for cities and win. And then when the city attorney for the first city that hired me decided he'd had enough of staying at meetings till 3 and 4 o'clock in the morning, which is no lie, that's what actually happened in that particular city at that time, he gave up the job, and they said, would I be interested in putting my name in the hat? And I had absolutely no business saying yes, so what did I say? Yes, of course. So I got the job. There were 18 firms that were interviewed, and all of them probably had substantially more experience than I did, except in litigation, and I got the job. And since then, I've become board certified, and this is what I do. It's about 60% of what I do, represent 4 cities, a bunch of different agencies, and I don't need to go all that. That's resume stuff. But the reason I'm talking about that is because I wanted you to understand that in all of those meetings, every single one, I have never been to a meeting ever that someone could not have reported, if they chose to, a sunshine law violation. And I'm confident that includes people in this room. So why am I telling you that? And this is the reason why. Because it is not what you think it is when it comes to the getting in trouble part. I will be able to easily explain to you what you cannot do. That's not the hard part. What I cannot explain to you is people's motivations. What I cannot explain to you is how people perceive things. And what I cannot explain to you is how important it is with this particular thing to be literally the proverbial Caesar's wife. And you'll recall that I started this lecture by saying, you are literally one vote away from being a hero today and a goat tomorrow. And if you've listened to my DVD, you heard that line. And I got plenty of examples of that. And that's why this is a very, very important issue to me. Let me start by saying this. If you go through your slides, you'll see that the Sunshine Law is not only ingrained in our statutes, it is also ingrained in our Constitution. So, in a very real way, when you violate sunshine, intentionally or not, you're violating the Florida Constitution, to which you all take an oath to uphold. Most people don't think of it this way, because that's not where we focus. We focus on 286.011. That's where everybody focuses. But if you read the materials, you'll see that in Article 1, Section 24B, all meetings of any collegial public body of the executive branch of state government, or of any collegial public body of a county, municipality, school district, or special district, at which official acts are to be taken, or at which public business of such body is to be transacted or discussed, shall be open and noticed to the public, and meetings of the legislature shall be open and noticed as provided in Article 3, and so on. How many people in this room knew that was in the Constitution before today? See, that's the reality. Most people don't, but it is. Here's the thing. I think the best way for me to explain how this perception issue is critical and why I am so passionate about conveying this to you is for you to understand how to learn from me being stupid. So here's how you do that. As a young, if you can believe it, I was actually young once, young city attorney, one of my cities, actually at the time my only city, said that they were going to have workshops beginning at 5:30 for an hour prior to the actual council meetings beginning at 6:30. And because at that time of day, most folks, including me, could not have gone home and eaten dinner, they decided that they would bring in sandwiches, pizza, whatever it might be, and we would sit around before the workshops at 5:30, say from 5 to 5:30, and we would eat. Now, we were doing so, what seems like a monumentally stupid idea now, in a conference room with a glass wall, not unlike the glass in the back of the room here. So everybody who wanted to could see where we are and what we're doing. They see the food on the table, they see us sitting there, the police chief, the fire chief, staff, and we're just sitting there, and we're talking. Now, I got to tell you, those are nice people, love them all. It was not exciting to be there. We were talking about kids' soccer, football, baseball, sometimes Yankee baseball, because at that time the mayor was a huge Yankee fan. Gator football, and so on. Never did the discussion ever sway into the area of anything that would come before that body. Not public policy, nothing. Not one thing. Now, in that setting, you would think we're pretty good. We got the police chief there. If we're violating the law, we got a bigger issue than the sunshine. We got a bigger issue. And this will probably really take you aback. While we were there eating a meal, in through the doors of the city hall comes a former mayor. Not some gadfly. Not somebody who just likes to be an irritant for the sake of being an irritant. I know y'all don't have those, but we do. But the former mayor, he looks through the glass. He then comes over to the door. We think he's going to come in and say hello. He pulls open the door and he says, quote, "This is the worst violation of the sunshine I have ever seen." And the door closes. And the next day, guess who was in the newspaper? 4 months we were investigated for a sunshine violation that never happened. Now, what is the end of the story? Well, if you heard the video DVD, you know. It's what you would expect. There was no violation. That didn't get rid of the headlines. That getting rid of the articles. And when finally, 4 months later, they decided there was nothing there, where did that get to be printed in the newspaper? Anyone want to take a guess? Correction, or errata, or whatever. But not that blazing headline that's still emblazoned into my memory, hence my passion for this issue. So how do you avoid that? Well, the only way to avoid it is to, number one, understand what the Sunshine Law is and what it requires and what it isn't. And after you have all of that understanding in the back of your mind, put in the forefront of your mind that you have to most be concerned with what people think you're doing, even more so than what you're actually doing. Because I'm going to give you the benefit of the doubt. I'm going to presume on your behalf, as your advocate, that you are not walking to the parking lot and trading votes. Because you would know that's wrong. And if you don't, God help you. I'm going to presume that before meetings begin, when you're sitting there talking to one another, you're doing the same thing we were doing when we were sitting there eating dinner. What I cannot presume on your behalf is what the people who are not there think. And neither should you. This was brought home to me in a very, very interesting way. Totally unrelated to sunshine, but it crystallized this thought in my mind. It's one of the reasons it underlines everything I do in this presentation. I was in a meeting in which the council had late on a Friday, the meeting was to be on a Monday, had been provided materials. And I was still relatively new at my job, sort of getting my feet on the ground. And the majority of the council was ready to proceed on this issue, even though they'd gotten materials, and it was a controversial one, late in the day on Friday. And so as it progressed, one of the council people, who happened to be the vice mayor at that time, was saying, hey, look, this was too late. We didn't get a chance to read it. They should have. And then that, because there was some political infighting, again, I know that doesn't happen in your cities, it just happens in mine. But there was a little bit of that going on. And so the then mayor was saying, well, I don't know why Mr. blah, 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 you didn't get to read it. We all got to read it. We're ready to go, and so forth and so on. I bet the city attorney read it. Mr. Shepard, did you read it? And I said, yes. And he wasn't mad at those guys, but he got really mad at me. And he said, I don't care whether Mr. Shepard read it or not. We are not ready. And I'm going, ooh, hello. I walked into that with eyes wide open and didn't even see what was coming. So afterwards, I went up to him and I apologized. I said, I didn't know. I was just trying to answer the question. Honestly, I'd read the material because I didn't want to come here unprepared. And he said these words that I will always remember. He said, son, a long time since I've been called that, son, I don't care what you think. I care what they think. And that should make the point for you. Because those are the people who will be the ones making the complaint against you. So what is a meeting that's a public meeting? Any communication between two or more of the same body, the same board or agency or commission, on anything that either is coming before or could reasonably be foreseen to come before your body, is a public meeting. And if it is a public meeting, it requires two other things to comply. It requires notice, it has to be held, and minutes to be taken. Those are the legal requirements for a valid public meeting. You have to have notice, minutes taken, and it constitutes a meeting if you've got 2 or more people from the same board or agency in place. So that is a significant issue, and that's a simple way to state the Sunshine Law. And as I said, it's a very few words. You've seen the statute. It's in here. It's not long. And as I've said many times, only lawyers could craft a statute that is so brief and yet so complicated when you actually get into its application. So why is that important to you? It's basically how you construe what a meeting is. Remember I said any communication between 2 or more members of the same board or agency. That includes, and I know you know this, emails. It includes phone calls. It includes note passing. It includes text messaging. And here's the least shocking, actual meetings. But it's those other ones that get you in trouble. See, the ones that are actually noticed by your clerk, they're not going to cause you an issue unless you're doing any of those other things, which I'm going to presume in your favor you're not. Walking to the parking lot, making deals. Walking in, making deals. Sitting at the podium before the meeting is called to order and making deals. Or whatever you might be doing regarding business, or having discussions about what you might do. Those are givens. Those are easy ones. But it's those other ones where things can get crazy. So with that said, one of the things that is made clear when you hear this topic discussed on the ethics website is that there's no way the law can keep up with the technology. If you think about where we are just 10 years from ago, if you go to look in the rearview mirror, heck, I remember when I got my first brick. Do you guys know what the brick was, right? I had the brick. If you threw it at somebody, they died. And now we're sending text messages. We got clouds. I can't keep up. And I'm fairly tech savvy, and I can't keep up with it. You saw how tech savvy I was this morning. So the reality is that as technology advances, the law is not keeping up, but the intent of the law is clear. Let me give you some examples of things that I think you will see in the not distant future if those things aren't happening actually right now. And this is actually old technology. What is the difference in your mind between text messages, which we now know thanks to the unfortunate foibles of Mayor Jacobs and the Orange County Commission, who got caught up in what we lovingly call over there TextGate. We know those are public records. But here's some old technology for you, a little old school. What about voicemails? What about communications on voicemails? Are you required, so far the answer is no, but are you required to save voicemails if someone is calling you and leaving a voicemail for you about city business? If that same person sent that same message to you in a text, we know the answer, right? But suppose instead of those lobbyists who were texting during the meeting, which is insanely stupid, but they were doing it, and those text messages then being deleted because there was no appreciation at the time for those being public records. What if those same lobbyists instead, as I suggest to you that might have happened, say, you know what, let's avoid this whole text message thing, I'll just leave them a voicemail. Can you not delete your voicemail? I don't know the answer to that question, and that's why this scares me. And that's why technology, whether it's regarding meetings and communication by texts, whether it's by emails, whether it's by voicemails, or any other permutation through various websites like Facebook and on and on and on. There's any number of ways that you can envision that the judicial branch and or ethics commission could see those things as just ways to get around the Sunshine Law, as ways to have meetings that otherwise people can't find out about. So that's a problem, and it's a problem specifically because the Sunshine Law has a unique provision in it. It is designed to evade, it is designed to defeat all evasive devices. And that's how the courts have interpreted it. And so, as you can probably imagine, and if you've heard this speech from others before, you know, all manner of efforts have been made to try to figure out a way to get around it. Leaving the state, you name it, all kinds of things. But at the end of the day, what ends up happening most of the time is a lot of heartache for the people who are involved. So it's just not worth it. So what else? When we've talked about public meeting, and that spectrum can be broad. Again, the key is that it's you and someone else on your same board or commission. It is not you and a staff member. It is not you and another member of a different board within the city. It is not you and the lawyer. It's not you and a constituent. It's you and another member of the same board. However, there's this little part of the law called conduit. Does anybody know what a conduit is? I do. In fact, I'm learning a lot about it right now. Over in Orange County, one of the folks who was charged in the Batterson matter was a guy named, you may have heard of him, Dorworth. He used to be the Speaker of the House. He then went into the lobbying business, and you might immediately raise a red flag about, wait a minute, I thought they couldn't do that. Well, they can't lobby the state legislature because that's where they work, but they can lobby other agencies, and that's what he was doing, in this case, the Orange County Expressway Authority. And these facts are not disputed. What happened, according to the facts that are not disputed, is that he, in doing his job as a lobbyist, would communicate with various members of the Orange County Expressway Authority about things that were coming up for them and tell them, hey, I think you should do this or do that or the other thing, and he would do the same with somebody else. And there may have been, this is disputed, there may have been some, well, I know he's going to vote for it, where are you going to go? There may have been some of that going on, but it was through the third party who was the lobbyist, Dorworth. Now, previously in my lectures on this topic regarding conduit, I have cautioned my city officials to beware because the conduit doesn't bear the brunt. The officials do. The conduit walks free. Not so fast, my friend, because Mr. Dorworth got charged as an accessory after the fact to being a conduit and facilitating violation of the Sunshine Law between the members of the Orange County Expressway Authority. And so he was charged, obviously not happy about it, and had to hire lawyers. And again, the point I'm trying to make here, because this story has at least at the moment a good ending for him, is that none of the things that have gone before the point where we're headed is going to ever come out of that newspaper. It's never going to come off a line, and if you do a search for his name, this is going to be one of the first things that's going to come up. So what happened? Well, what happened is a motion to dismiss was filed on his behalf, and ultimately granted by the judge, saying that since he was not an elected public official, that he was not subject to the Sunshine Law and had a First Amendment right, which makes sense when you think about it, to talk to whoever he wanted to talk to, including public officials. In fact, why wouldn't he? It's their job to know what they shouldn't be sharing between one another, and he's okay to go. So the charges were dismissed. But I would suggest to you at a price that he wished he hadn't had to pay. And immediately upon the dismissal, the state attorney over there, who was fairly aggressive, you may have heard of him, Ashton, Jeff, he announced that he's going to appeal. I do not know whether the appeal is ongoing or not, but that is the status of the case as I know it. And why is that important to a guy like me who's a city attorney? Because I have to go between you guys all the time. And as a matter of fact, I'm now under investigation in the exact same way, because there's been a charge, not a proof, that I have communicated between one member and another regarding a matter which they were voting on. Now, I know I was there, but that's not the issue. And that's why I'm so hard on this perception thing. And particularly now with the conduit issue being, at least in our circuit over there, it's not necessarily migrated here, because right now the only person who's doing this is my guy, Ashton. However, for your point is, when things start one place, we love copycats, right? And so they tend to spread. So I think it would behoove me to share with you from not only Mr. Dorworth's misfortune, but my own, until it's resolved, to understand that conduit issue is important to you. And how it can bite you is really important, because it's the one that you would least suspect. Now, let's talk about how that works, and then I'm going to talk about the other requirements. We're going to get into this, but this is an important thing. It's probably, if I don't tell you any other thing today, this is the important thing you need to understand, because it's where it's going to get you. If you are in a council meeting, or if you're not in a council meeting, let's suppose you're at a social event, and somebody who's in the community comes to you and says, hey, this development issue that's coming up, I would literally like to know where you stand on that, because I've got real concerns here. You would fully expect to engage that constituent in discussion, tell them what you think, tell them what's on your mind, you listen to what they have to say. That would make you a good politician. That's what you should do. But the danger in that you have to caution yourself is, what does that person then do with the information? Okay? You can't control them, but you have to be aware of it. So here's what happens. And the example I use, some of you will be old enough to remember the old light beer commercials. Tastes great, less filling. Tastes great, less. And there's a guy in the middle who's the instigator, right? And then as soon as the people start fighting, he steps back and just watches the melee. Well, in the political arena, here's how this plays out. They don't pick on you because typically they just want to know what you think. They're trying to start something. Because what they'll tell you, as soon as you tell them I was talking to so-and-so, and they're going to do the opposite thing. And they said, you're crazy. They said, you're full of blah, blah, blah. And if you let them pull you into that situation, you go, well, they're full of blah, blah. And the next thing you know, they're running back to the other one. Said, well, when I talked to so-and-so, they said, you're the one that's full of it, and you didn't, and blah, blah, blah. And now the fire is blazing. And the conduit is just watching it all burn down. And at the end of the day, when you get reported, you can say, God, I let myself get baited into that situation. How do I know this happens? I was minding my own business one morning, and I got copied on an email trail. And it went something like this. The Fiscal Advisory Board of a given city had a meeting the night before. I don't typically have to attend those. 2 members of that board had gotten in a very heated, but public, happily, discussion of whatever the issue of the day was. I don't even remember, doesn't matter. And upon reflection, after they had left the meeting and cooler heads had prevailed, one of them thought, I shouldn't have acted that way. Said, I should apologize. And I'm going to do that, because that's just the right thing to do. And right now, if I stop the story, you say, well, what the heck's wrong with that? That's good. That's all good. It's polite. It's self-effacing. It's whatever it is. It doesn't sound negative until I tell you that how he apologized was he sent an email in which he copied me and others to the other official on the same board, apologizing for what he had said, and then further explaining what he was trying to say. Oh, my.
Would it have been okay for him to say, hey, I'm sorry, I got out of hand?
Well, the question was, would it have been okay to say, it's okay, I'm sorry it got out of hand? The answer is, if that's where the story stopped, yes. But what does Paul Harvey used to say? And now you know the rest of the story is it never stops. Because as soon as the first one sends the email to the second one and has an audience, which includes the city attorney, the second one cannot let it go. And so here we go. The conflagration has begun. And so I'm telling you this because these things are human emotions and they run through us all, and we're not going to get away from them. And the only way to protect yourself is to understand what's happening and what's really happening. And so with that kind of as the backdrop, and why conduit is such a particularly thorny issue for you, because it can happen in any number of ways, and you can't control it. But as soon as someone comes to you and says, I was talking to Commissioner so-and-so, and they said whatever they said, I'm done with you, I'm out. Okay? Now that may seem harsh, but your name in the paper is harsher. I just trust me on that one. Yes, ma'am.
But just to clarify, my understanding, and you can let me know if I'm way off base, if there is a one-way email communication from an elected official to a bunch of other elected officials, as long as no one responds back, that's not a violation.
That is correct.
Once someone responds, then you've got a violation.
It is the fact of it becoming two-way that creates the issue, which is why I said first of all, again, I got to remember the tape. The question was that, and I was asked, is it correct that if the communication via email, for example, to any other member of the same board or commission only goes one way and there's no reply, is that a violation? And the answer is clearly that is not. It is when you reply that it becomes a problem. But the reason that is little solace is the temptation not to reply with something you so strongly disagree with is almost overwhelming for some of you. It is absolutely, it's like me trying to drive by the Hot Donuts Now sign at Krispy Kreme. It's not gonna happen.
But so that means you could, what your agenda is coming up, and you could send something out to the whole rest of the council and say, I'm gonna vote yes on this one, no on that one, yes on this one.
Yes, you could do all of that, assuming that none of those decisions were quasi-judicial. You could do all of that, and you would immediately own the deserved enmity of everybody else who you've now effectively shut up. And so that's the second part of my advice to you on this subject, which is your voice is not the only one. And when you then speak in a way that ties the hands of others, and particularly, and this is what I love, we have a lot of this in one of these towns I represent, where there's long email lists of hundreds of people. And so one politician broadcasts their views to this major email list, and in the same time taking swipes along the way as appropriate to whomever they don't agree with on council. And now I'm on the same email trail if I'm a council person, and I can't say squat. This is not fair. It is a wrong exception in my opinion, but it is an exception, and that's why I urge you not to use it. They characterize this as a position paper. You are allowed to put out a position paper. Again, if it's not quasi-judicial, because as I think you all know, you have to do those decisions based on evidence. But on legislative matters, you can run on them. You can say, when I get elected, I will, fill in the blank. And that's okay, but not quasi-judicial. So you could put out a position paper, but when you do that and you do it in this manner, you now tie the hands of the other people who you're supposed to respect their opinions as well. You may not agree with them, but they're elected too. So it usually usually ends badly. All right, so before I spend my whole talk about those things, let me fill in the other blanks. That's been tried, and my county, Orange County, tried it. City of Orlando tried it. They were trying to have certain meetings in the Citrus Club, and if you're not familiar with that club, it was a private club at the top of what was then the tallest building in Orange County. Very nice, very expensive, and very not public. I said, the public can come in here, but they couldn't afford to come in there because of the cost of breakfast or whatever, and it was not conducive, and that was a big McGill many years ago. So it's got to be a public place, got to be reasonably noticed. You've got to have minutes. Now, we have a lot of misconception out there, probably in this room, about what minutes should be, or what they're legally required to be. What they should be is what y'all want them to be, as long as they meet the minimum standards. But they're not, as many of my cities make them, Bibles of incredible depth and meaning, that's single-spaced and, 15 pages. What they are supposed to be is who's there, who's not, what motions were made, and how the vote came out, and then when they were adjourned. That's what's required. Everything else is surplus. That doesn't mean you don't want them. You might want to put it on there. It may be a great historical record to you to talk about what was discussed and what points of view were put out there and dismissed. That's not the requirement. So I point that out to you because some are not even aware of that. But if you would do all those things, have a publicly noticed meeting in a public place and have minutes taken, you have technically complied with the Sunshine Law. But as you already know, based on the condo issue, that's not the end of the story. So what do we need to do? Yes, I heard a question. Yes, sir.
On the minimum requirements for minutes, is there any benefit to limiting your minutes to just those things?
In my opinion, absolutely, but nobody listens to that opinion. None of my cities listen to it. But it is, yes, it is my opinion that it is. Because what happens, see, I'm the lawyer. I'm not the historian. And sometimes those minutes can be the anchor around your neck in litigation. On the other hand, they might be able to help you. But my experience is more often they're going to sink you. And so that's for whatever it's worth, but I will tell you, there's not one of my cities that does it that way, or with those bare bones. Now, another question that's covered in here is a draft a public record, and the answer is yeah. If you do draft, and somebody says, well, it's not a public record until we do the approval. Now, that's not true. As soon as any document, and it's not just minutes that are in this category, that's not an exempt document, is prepared and distributed to communicate public business or anything regarding public business, it's a public record. So that answers that part of the question. We've covered the accessibility. It would preclude private clubs. It would preclude expensive restaurants and so forth. I see your hand, sir. Go ahead. Yes, was that you?
Would your advice be then to delete from your electronic devices any people that you need to speak to at Sunshine Law?
Would it be my advice to delete them? Well, the answer would be, well, deleting them wouldn't solve the problem. Blocking them might. But I don't know that it's that extreme. Again, the issue is not deleting them from the device. It's not responding to them. Again, the key to the whole issue is communication that is back and forth, whether it's directly or whether it's indirectly through a conduit. And so that's really the key to it. If I get I know you can't see it. I've been getting texts from my wife when I'm sitting here, and she's saying, I hope you're doing a good job. And I said, well, they haven't left yet. And, very nice things to say. But the reality is I see my councilmen get this stuff all the time, and I often wonder what it's about. To your point, the question being, should you delete them from the device? It's that you shouldn't respond to them. And again, that's why I point out that if one of your members is as insensitive on an issue that they know is the business of your agency, to send you something like that, whether they did it intentionally or not, they've effectively tied your hands. And that's why I caution against it. There's no exception. If it were to happen, and I guess it's possible, that a husband and wife were to be elected to the same group, that same rule would apply. And it would certainly be a difficult situation, but if it dealt with city business, 100%, there's no exception. There's no spousal, family, father, son, mother, daughter. There is no exception. It's what the nature of the communication is that makes the violation, and if it's two-way. But that's why this thing of appearance becomes critical, because you heard me say, as vociferously as I can, I've never been to a meeting that someone couldn't be reported for a violation because of perception. And that's why I get just super concerned about what usually happens before and after meetings. Whether it's we're sitting to ring down the gavel and everybody's up here chatting, and microphones may be live or not. Some places it's broadcast over streaming, you name it, and you don't think about it. After a while, you get oblivious to those things. I know I do, but I'm not the one who's going to get in trouble. And so you need to be really cautious. And as I said, I'll assume in your favor that you're not doing anything that's untoward. And in this case, I can actually use Ms. Lewis as an example because I'm sitting there as a city attorney. I'm not on her same board. I just happen to be the town attorney. But we've had a citizen say, I need to know what they're talking about while we're in a meeting when I'm trying to provide legal advice during whatever it is. Now, there's no sunshine issue there, but there was a real concern, and I get it because it's appearances that make a difference. So that's important to understand. Now, why else is this important? Well, there's a lot here about the crime being up to a second-degree misdemeanor, attorney's fees, and all of the things that go along with it. One of the things also that people don't generally fully appreciate is that actions that are taken in violation of the sunshine are void ab initio. That is a fancy legal Latin term, which means as if they never happened. Now, why is this a critically important thing for local government officials? We don't think of these things as having a significant monetary price tag. Even to us personally, if we get caught up in them, the fines are not that high. There's that minor potential for going to jail for a little bit, but in terms of the monetary impact, we don't think of that as the same deal. But to the cities that you represent, it could be huge. Imagine, if you will, the following scenario. You are on a local hospital board. Y'all might start to listen up here because you'll recognize this case. And you start considering a merger, it's a public hospital board, with another hospital. And you meet behind closed doors for over a year to discuss the merger. And you approve it. And you do it. And for a year, the world is a wonderful place. Until the circuit judge says that the entire action of the merger at millions of dollars of costs is void ab initio and must be undone. Do I need to tell you what that was? The reason this is such an important thing is I think it underscores in a better way than anything I can tell you would. This is important stuff. Even if you get a slap on the wrist. And in that case, nobody got a slap on the wrist. But some people had to pay a bunch of money, including the lawyer that gave advice that was okay to meet behind closed doors. And so this is not stuff to be fooled around with. That void ab initio thing is as big a deal as anything else I could tell you about. Because you get some big development coming through your town, and it turns out that when you approved it, there was a sunshine issue. And the developer now, because of no fault of his own, somebody gets sued. I'm telling you right now. Yes, ma'am.
And sometimes that violation is so inadvertent, because I had a situation in a city that I was facilitating their charter review committee, and we thought all of our meetings were being noticed, and then one citizen sitting in on a meeting said, I didn't know anything about this, and it turns out the clerk had not noticed every meeting, only some of them, and we had to go back and redo everything that we had decided in the last 3 months of that workshop. And that was totally inadvertent, but we were in violation of the Sunshine Law.
The speaker, who happens to be Marilyn Crotty, and some of you will know exactly who that is across the state, has made a valid point, and it actually goes to another thing that we want to talk about regarding cure, and that is that sometimes violations are inadvertent. You show up as the public official and you assume that it's been properly noticed, and you find out only after the fact that that's not happened. Now, that is a rare occasion, but it can happen, and in fact, in a fairly recent episode, in the last 6 months, it happened to me. Not me personally, because obviously I'm not the issue in this particular matter, but I was sent a staff invitation to show up at a meeting by the planning director, and he said, hey, can you show up? We're going to be talking about X development. I just assumed it was staff. I show up, and it's staff, all of staff that's involved in what they call the DRC. Do y'all have DRCs or something similar called the Development Review Committee or something along those lines that goes through developments and looks at various aspects, police, fire, public works, and all those things to make sure everything's going to fall in line? Well, DRC meetings, which are typically staff heavy, in fact, they're almost always all staff and perhaps the applicant, they are covered by Sunshine. A lot of people don't know that, but there's an opinion on it. They are covered by Sunshine. They're supposed to be meetings that are noticed and everything else. So I show up and I start looking around the room and I realize, God, these guys are all the department heads. This kind of looks like a DRC meeting, and I see developed there. And so I'm thinking, oh, well, this is a DRC meeting. And so we begin to talk, and the agenda goes on and on and on. And then after the fact, I find out that the person who sent out the notice just noticed all these same people who were on DRC, but it was not a DRC noticed meeting, yet we were talking about the very kinds of decisions regarding this development that come before the DRC. So you can, as Ms. Crowdy points out, be caught up in an inadvertent situation. And here's the bad part. Depending on how severe and how long, one of the things about Judge Graham, and Judge Graham is the order that was entered in the Burt Fish case, said that there is a certain amount of infection that no amount of sunshine can cure. And the reason he said that is because in that case, as far as we know, the most expensive efforts at a cure ever envisioned in the state of Florida were attempted for a year of going back and doing new meetings and making a whole electronic public records room available and making the whole decision process transparent again. And the judge said, at the point at which they'd made the decision, after a year or more of consideration, there isn't enough disinfectant in the world to solve that problem. And that becomes important because there were other aspects, kind of things that are not in the details of the newspaper as to how could that be. Well, one of the reasons that could be, and this is an unhappy result, is that the same people were making the decisions, which when you think about it in retrospect only makes a little bit of sense. If you really want to disinfect the decision-making process from having been a bad process, you got to get rid of everybody. How many of you want to turn in your resignation on that basis? That's the problem. So there you go. Now, the Sunshine Law gets short shrift because most people don't get it, when they're particularly from your boards. If I would tell you who's going to have more likely of screwing this up, it's not you guys who probably hear it on a much more regular basis than it is your volunteer boards who really don't get the connect between nobody's paying me to do this job, I'm very civic-minded, leave me the heck alone. And that's the attitude. They may not say it to you that way, but that's the attitude. And they don't think it's serious. I want you to look at this slide. I don't know the number here. Anybody recognize W.D. Childers? Anybody know who that is? W.D. Childers, for those who aren't Florida legislative historians, was the former Senate president of Florida, and he was well known for fistfights. In fact, one of his great targets of fistfights was a guy named Dempsey Barron, and some of you will know exactly what I'm speaking of if you've been a long-time Floridian. Well, after he got out of the Senate, he decided to get involved in local politics again because, as I say, some people, it's an addiction. And you'll see him with a nice smile on his face as he's packing up going to jail for violation of the Sunshine Law, 60-day sentence. Not his proudest moment. Now, if you know Childers or you knew him historically, you would know that it probably didn't bother him all that bad. But I would suggest to you it's not a good day. even for him. And so that's why this stuff is to be taken seriously, and it does have consequences, and those consequences will follow you. It is, as I said, it's broadly construed to affect its remedial and protective purposes. It's applicable to elected and appointed boards, so the information you take here, you need to take back to your appointed boards. The design is to let the public be aware of all parts of the decision-making process. All parts. As I say multiple times, it's the opportunity to see how the sausage is made. Me, I'm just an eat it guy. But if you're a member of the public, you're entitled to see how it's made. It includes recommendations. So even if you're only on a recommending body, that's a part of the decision-making process. Well, of course it is, because what do you say? Well, what does that board say? Well, they recommend. Then that's a part of the decision-making process. So it's not closed. We've already talked about exchange of written memorandums. That's the so-called position paper, and the fact that it keeps you from responding and therefore creates a problem that you would really rather avoid if you intend to have any collegiality amongst the other members of your agency, and that's important. One of the exceptions I spend a fair amount of time on, because it's the one I get asked about most commonly, is the social events exception. And if I could literally erase 3 words from your memory banks today, those would be the words, because it's not an exception at all. Here's what it's meant to do, and here's how it actually works. What it's meant to do is say that you and your colleagues can go to, for example, recently we're off the holiday season, a Christmas party, a New Year's Eve get-together, whatever the situation may be, in a social atmosphere without a sunshine law violation taking place. And that, as kindly as I can put it, is a load of crap. And here's why that is. Because, as I said at the beginning of this, it's not where you are that matters, but what you talk about. If I am at a cocktail party with you and I'm on your board of commission, it will be no defense to you, if we're talking about city business, but it was at a cocktail party. It will be no defense to you if it was, well, we happen to be on the same plane together. It will be no defense to you that, well, I didn't know. So it is, to me, it is an abominable exemption to discuss because it gives false hope where none exists. The same exact rules apply. It really is a meaningless exception. It says you can cure a violation, and we've talked about how that's not exactly the case. Sometimes it will work, other times it won't, and there's no guarantee, and you know what happens if it's something where there's an expensive price tag, void ab initio. Summary, notice, public location, minutes. That's what you need. I get asked another question. Well, if I can't talk to my fellow members on the boards that I'm on, what can I do to get questions answered? I mean, some of these people are real knowledgeable. You know, I got lawyers, I got accountants, I got all kinds of folks that know stuff that would benefit me, and I'd really like to get their input. Well, that's what the public meetings are for. That's where you get their input. But that's not the only source. You have your staffs. You have other members of other boards that are not yours. You have state resources. You have your attorneys. You have whatever else you need. But at the end of the day, if you really need to talk to the folks on your board, that's what the meetings are for. It's ironic to me, and it is something that even I have fallen into the trap of griping about from time to time, that we have meetings that are complained about by constituents because they go on too long. And they go on too long because this is the only opportunity that you all have to talk to one another. And so those same folks that gripe about those long meetings, and I understand because I'm sitting there wanting to go home like everybody else on Monday night and watch the football game, that they are the ones who will report you for what they perceive to be a violation of the Sunshine Law because you were talking outside the meeting, so the meeting would go quicker. But that's the reality of the situation. Those meetings are designed to be your opportunity to put it out there, to have the dialogue, have the debate, and let the public see what's going on. That's why. Yes, sir.
What is your opinion on board members attending advisory board meetings?
Great question. What is my opinion on board members or council people or whatever attending other board members' meetings or other board meetings. Here's my opinion. You do not give up your right to advocate as a public citizen because you are now also a publicly elected official. You do not give up that right. If, for example, you wish to go before the P&Z that's considering a project you have issues with, and it's legislative as opposed to quasi-judicial, which you're not supposed to decide on until it's in front of you, you have the right to do that. If the P&Z or something is considering sending up a piece of legislation that will come before you, that you have concerns about how it's being crafted, you don't give up that right. But what you have in that situation is if you show up and you speak, you're in a meeting that's publicly noticed, minutes are being kept, assuming it was all done properly, but you've now created an issue because nobody knows you're going to be there. So they're expecting P&Z, they're not necessarily expecting you. And so how do we address that? Because I got cities that do exactly this, and it's usually with land planning type issues. So what do? Here's what we do. We put on our notices of those meetings, whatever the board may be, that one or more council members may attend this meeting and may speak. That way, nobody in the public can be blindsided by the fact, well, I didn't know that they'd already spoken about this here, and that didn't tell me that on the notice, or I'd have been there to listen to what they had to say. That's how we solve that problem. But I would caution you this. What happens when council people, particularly those that get along, show up to the same meeting? Where do they typically sit? I can tell you because I've seen it. Don't do that. Just do yourself a favor. Love them later, but sit on opposite sides of the room. Please. Because of the appearances thing. Okay? Now, we covered the new challenges, and if you go to what is the last slide in this particular part of the presentation before we move on to public records, digital age sunshine, and you will see where it talks about all the issues regarding how are we going to deal with this digital age going forward. There's so many things I can't even begin to get my head around it. Here's the best thought I can leave you with. If it feels like it's a problem, it's a problem. And the fact that nobody said it's a problem yet doesn't mean it won't be a problem for you. So, do yourselves a favor. Do your families a favor. And do your constituents a favor. Know the law, and whatever looks like the wrong thing, do the opposite. That's it. Any questions on this before we move on to public records? Yes, sir.
Just to follow up on the commissioner at FLC meetings, if more than one commissioner speaks, how is that different than the position paper not responding?
If it's you're talking about a meeting which is or isn't noticed.
Which is noticed.
If it's noticed, it's different because it's noticed. Because it's noticed, people know that it's going to happen. There are minutes being kept because it's a P&Z meeting or whatever board it is, because unless you have boards that aren't minutes, that's a whole other issue. But I'm assuming they're following the law. Those boards are. So you have the minutes already in place, and you have the notice in place, and if you put in the notice that council people are going to be there, you've solved the issue. Yes, sir.
It's not uncommon for a council member to meet with members of the staff.
It's not only common, it's supposed to happen. That's what's supposed to happen.
Right, especially on items that will come up for a vote. That means that those meetings have to be publicly noticed?
No. Council member, singular. But if two at one time went, that would be a problem, absolutely. But for you, for example, or anyone else in here, to individually go to the city manager, the finance director, the whomever, the planning person, whomever it might be, and say, can you explain how this works? Tell me how the zoning situation is, or what would be more appropriate, or how do you feel about this issue? And ask questions. This is okay. And in fact, the irony is, were I talking to a room full of staff, which I frequently do, I would tell them to be on their guard so that they don't become conduits between you. Because you're supposed to be able to go ask them information, and they're supposed to know better than to convey what you say to the next one. And so if you come in, for example, and say, what is the situation historically with this blah, blah, blah zoning district? And they say, blah, blah, and you express your concern about it. And then later on, the mayor walks in and says, hey, I have a question about this. Well, it's funny, we were just talking to Councilman so-and-so, and here's what they said, and I've got, he's concerned, and so I will show you. Now, they're doing exactly that which I'm warning you about. They're being a conduit, and you can't do that. The simple way to put it If you can't do it directly, you can't do it indirectly. Anything else on?
How's that my fault?
Well, the answer is, what did you know and when did you know it? In other words, in that situation, if you're the one that's left the room and you don't know what happens after, but now I'm on the receiving end. Now, in my example, I'm the mayor, and staff are saying, hey, I just talked to Councilman so-and-so, and he said this, this, and this, and this, and this, and this is what we think about that. As soon as he says, Councilman so-and-so, done, stop. Don't say one more word about that. I need to know about this issue. I want to know nothing about what so-and-so said. That's your responsibility. So the one who walked out early, he's golden, unless staff then goes back to him. But the one who's on the receiving end of that information has got to stop it. The purpose of Chapter 119, which is often lumped together with 286.11 as the Sunshine Law, really is a separate provision. It is not the Sunshine Law. You might call it a part of the Sunshine Law package, if you will, but it's a separate statute and it stands on its own. And it's all about public records and what is and isn't available. The purpose of it is to perpetuate, communicate, and formalize knowledge. And if it meets those criteria, it is a public record if it involves public business. What does that include? Well, as you've already heard us discuss, it includes text messages. It includes emails. It includes memos. It includes letters. It includes minutes. It includes receipts. It can include any number of things that deal with the public business. It includes emails from constituents that you wish they hadn't written to you so you don't have to share them with other people because they're embarrassing. Why would I be talking about that? Well, it happens. And, it's I feel for these people. I kind of, as you may have been gathered from listening to me, I can be a fairly passionate person at times. And I have to put that passionate part of me on the shelf when I'm in the public meeting arena. So I sympathize with those who, for example, when they ran for election, were saying a lot of colorful things about their opponents or the other people with whom they're going to serve. But the problem with those colorful things is that they can come back to bite you when someone makes a public records request and all of a sudden that gets out there. I said, boy, I sure wish I hadn't said that. Is there anybody in this room who has never said these words? I wish I hadn't said that. Is there anybody? Okay, it's just not, that's not normal. That's not who we are. And if you're in politics, by your nature, you're passionate at some level about something. But, there's no exception for, well, I didn't really mean to be this rude. Or I wish that constituent hadn't ratted me out by saying, Joe, you remember when you called that so-and-so a blankety-blank, blah, 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 blah? Dadgummit, I wish I hadn't said that. So that's why this stuff becomes important, and here's why. It's an issue that's covered by Article 124 of Section 24 of the Constitution. Again, a fun fact I'm certain most of you did not know. But here's the interesting thing. A lot of people assume that public records duties stop at the clerk's office. Hey, don't look at me. I'm not the clerk. If you are in possession of a document that qualifies as a public record that has never been provided to the clerk or anyone else in the city, guess who is the custodian of that record? That would be you. That means that you are now under a statutory duty to timely comply with a records request assert exemptions if there are any available. Not you can, you must, and you don't even know what they are. Why? Because I don't even know what they are. There's so many, it's ridiculous. You don't know what they are. If you're going to charge for them, you've got to make sure you charge the amount that's allowed by statute. It's a pain in the neck. But why do people do it? Well, I already told you why people do it. Because until there's a request, they don't want those emails that all of you have gotten at one time or the other to be on the radar screen of other folks. So you have, wittingly or not, become a records custodian if there's ever a request for those records. 100%. Whether you're in or out of office. That doesn't lean, hey, I skated through my term, I'm now out, and nobody gets to see those. Because if they get a records request and you got the records, they are still records. Doesn't change. Yes, sir.
Does it apply to just your official email, or does it apply to somebody that sends you something to a personal email?
That is a great question, and it matters not a whit. The question that I was asked is, does it apply only if it's to your government account, or does it also apply to your personal accounts? And the answer is, to be exact, it doesn't matter one whit. Just like the communications that we talked about that make a sunshine meeting, it's the nature of the communication that makes it a record, not what account it came in on. Yes, sir.
Does it matter whether you respond or not?
No, not if you're an elected official. This is an important point, but it's a good question. The question is, does it matter whether you respond or not? Here's the answer to that. If you are a public official, meaning you are either elected and holding office, or a commissioner-elect or council person-elect who has not yet taken office, but you're considered elected for the purpose of sunshine, and you get an email in, your response doesn't matter. If it's about city business, it's a public record. So even if you don't respond, so you're not necessarily embarrassed, but you think the constituent would be, sorry, they need to think too before they hit that send button. In fact, some of you will know, and maybe some of you don't, you will see on your websites, if they're compliant, and I'm presuming that they all are, what does it say about emailing a city? If you email a city, what does it tell you? Not only is your email public, your email address is public. Period. And people request those, and they not only can they request them, they do request them. So this is not an insignificant issue. And why does this become another issue that I have unfortunate personal experience with? Let me tell you about the time I almost got fired. It happens. It hadn't happened to me yet. But it could happen. You know, at this point, when you've served at any city for 15 or 16 years, your lifespan seems to get shorter and shorter. But here's the reality of the night I almost got fired. There was a very controversial development project going on in one of my cities. And it was a 3-2 split council. I know that's also unusual, but it happens. And the development had been approved. And timing-wise, just as a historical matter, if you remember Hurricane Charlie, the development was approved on the Monday following the hurricane, which hit on Friday, which becomes central to the story. As a result, very, very few people were in attendance at the meeting, but the council decided to go on, despite advice that it might have gotten from someone, and hold the meeting. And some citizens objected and said that this was inappropriate because they were still in their homes clearing trees and debris and a lot of other things and so forth, a lot of which, by the way, turned out to be false. But nevertheless, that was the claim. And still, from a judgment standpoint, you can certainly question whether they should have continued that to a later time. And they didn't. They went ahead and approved it. So there was a lot of bad blood over it. But a lawsuit was brought, and I'm the city attorney. Can anyone guess on what side of this I'm supposed to take if it's a 3-2 vote? The 3, right? I don't have a choice. It's not like I get to vote. There's no tiebreaker. If 3 people say, defend the lawsuit vigorously, I'm defending the lawsuit vigorously, but that really is upsetting to the 2 that didn't win the vote. So here's what happens. We get into the litigation. A lot of the information about what the litigants had claimed was true was demonstrably untrue. All the roads were clear, the electricity was back on, and a whole lot of other things. I'm not forgiving what the council did in deciding to proceed, but what I am telling you is the litigants lied under oath, and that was the problem. And so as a result, they were sanctioned. The judge entered an order sanctioning them for attorney's fees because after we took their depositions, the story fell apart. That really, really torqued the 2. And it just happened that it was come upon election season. And a new member was elected to the body. I didn't know anything about the new member. But the meeting that they were to take office, just after they were to take office, one of the two noticed reconsideration of the contract of the city with the city attorney. Now, the litigation is ongoing. The sanctions was a separate matter. The litigation is still ongoing. And the idea was, well, we've got a new council member now. We're going to get rid of this guy. He's too aggressive, and we're going to move in a different direction, and maybe the litigation will go away, and maybe we'll just can this development right now. Again, I couldn't have cared less. I'm just doing my job. But nevertheless, the motion comes up. Packed house. 400 people were in the high school auditorium, standing room only, and lots of controversy. This issue comes up. The councilman that brought it introduces it, says he's lost confidence in my abilities, and all the other nasty things you can imagine get said in that environment. I don't say anything because it's not appropriate. They can fire me if they choose to, it's fine. And I'm just minding my own business. The next thing I know, it goes down the die, and it comes back, not surprisingly. First, you get to the deciding vote, and the deciding vote is the new guy. In the physical dynamic of the situation, because it was a high school auditorium and we didn't have like a curved die, it's a straight table. I'm here, the guy that wants to fire me is here, and the new guy is here. It was very comfortable, and I got a warm feeling all over. And so we get to the new guy, and who I have never met, and he says, well, I've done my research, I've checked around, the attorney has an excellent reputation, he's doing what he's been told to do, and it appears that he's winning, and I see no reason to get rid of him. After I get my win back, the mayor, who is sitting directly next to this guy, the new guy, says, I think we need to take a recess, because he can tell you something that I can't see. And that is that the people in the audience are looking very, very strongly at the guy who wants to fire me. And I don't see it, because I can't see him. He had turned purple. He was about to explode with anger. And so they called a recess to get him the opportunity. And when they did, that's when I find out, because the public comes up and says, Mr. blah, 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 what is wrong with you? Are you, and they lied into him, and I didn't even know what's going on, so we have a little break. Hopefully everybody cools down. Now the chairs get shuffled. Now I'm not next to him. Now I'm still next to the new guy, but there's me, the new guy, and the guy who wants me fired. The next thing I know, when the meeting's reconvened, about a minute, and I get poked in the ribs by the new guy. And he points to a piece of paper, and he shoves it over to me and says, look at that. Look at that. And what does it say? In capital letters, underlined very angrily, Judas. Now, I'll leave it to your imagination as to why he might have had that opinion. I'm suggesting to you that it certainly could be argued that there might have been a sunshine issue going on there, or he would not have had any way to know or expect what was going to happen with the new guy. But something happened. Well, of course, when you see, and you're sitting out in the audience and you see somebody going, look at that, you know what happens next. Do I need to tell you? I want that record. Front page news next day, Judas. And of course, to which I was famously quoted as saying, well, if that guy's Judas, then I guess the other guy's Jesus Christ. That's all I know. So, otherwise, I have no comment. So there you go. I promised you when I came in here I'd give you the good, bad, and the ugly, and that's local government as we know it, and I'm probably preaching to the choir. You all know what I'm talking about. So there you go. If you have custody of records, therefore, that are yours, that are really not yours, that have not been transferred to your clerk, you can either, what does the taxman say, you can pay me now or pay me later? Or maybe that's your car mechanic, but either way, it's the best thing for you to do, to make it your habit, to copy to the city clerk anything that constitutes a public record as soon as it comes into your possession, for a couple of different reasons. Number one, it's not going to get any easier to do just because you hold on to it longer. You might as well get the pain over with, rip the scab off the wound, and move on. Secondarily, it shifts the burden to comply with the record request away from you and to the clerk who is paid to do it. And third, it will be the sooner you can inform your constituency that when they just start sending to what they think is your private email, that it's no longer private, you will see that the tone of those emails will either change, or alternatively, you will have no hesitation about forwarding them to where they belong to be, because you will have disclosed to that person what position they're putting themselves in by doing so. And usually it self-polices itself. There are some, I was going to say fanatics, that's not appropriate. There are some enthusiastic citizens who will not care. They'll keep on writing them, and they'll say whatever they'll say, and they'll use whatever language they'll use. But you've done your job. You've tried to warn them. At the end of the day, that's the way to handle the situation. What is your duty if you choose to remain the custodian of those records, despite my great advice just now? Well, the first thing you must do is you must promptly, and that means like right away, respond to a request and acknowledge it. So let's suppose a citizen, happy with you or unhappy with you, sends a records request to you, says, I want all the emails of John Smith between this date and this date. And John Smith says, I guess I'm going to have to get around to that at the end of this week and look at it, and then maybe I'll get somebody from IT to come over and help me figure out how to do this. I'm not really computer literate in terms of going back and searching these things. I don't know what to do. You've already screwed up. Literally, as soon as you get the request, and that's been interpreted as within 24 to 48 hours, you need to acknowledge the request. Mr. So-and-so, Ms. So-and-so, we've received your request, and we're working on gathering the documents, and if appropriate, an estimate of what it will cost to reproduce them to you pursuant to the statute, and we will be back in touch with you as soon as we can get the records or get an estimate to you, whichever is appropriate. The failure to acknowledge the request is in itself a violation. Okay. I have also told you that one of the reasons I hate you being your own records custodians, even though some of you insist on doing it, is because you have a statutory duty to assert necessary exemptions, and you don't know them. I say this with great confidence, as I said, because I don't know them. There are very, very many, and you need to know what they are. The obvious ones we all would know: Social Security numbers, addresses of certain types of police and law enforcement, and so on and so forth. But there are other things you may not even consider. And so, you have a name and information regarding a juvenile, regarding whatever the issue be. You may not even recognize that as an issue, and yet it is. And if you produce the record that was supposed to be exempt, you have as much a problem as if you didn't produce a record that wasn't. So that's an important thing. And if you happen to assert an exemption, or alternatively do a redaction, meaning strike through a Social Security number, whatever, it's also incumbent upon you to, in your response, cite the exemption that you believe applies, so that the other side can see whether they agree or not. And at the end of the day, if they don't agree, so that a reviewing court can look at it and see whether they agree with you or not. And again, and I know some of you have approached me in the room and are attorneys, so I know there are at least a few attorneys in here. But for those of you who are not, that's not something you want to be doing without some help. Your own city attorney, town attorney, whatever it may be, personal attorney, but you do not want to be treading that water without help. If you are going to be inundated with requests, again, I don't know, it just seems it's always my cities. I know this doesn't happen to you, but there are people who just make requests repeatedly for thousands and thousands of records. It happens in my cities on a regular basis. How do you address that situation? Well, here's the answer to that. You address it by using the only tool the statute gives you to utilize. You look at the fee schedule that's provided to you in the statute, and you provide a written estimate that says, based on 30,000 pages of this and the review that's going to be required to see if there are any exemptions, the cost to you will be based on the minimal amount that it would charge for the person of the lowest level of skill who could adequately do the work, will be $455 or whatever the number is once you do the arithmetic. And you send that estimate before you make the copies and before you pull the records, and you ask for them to make a deposit in that amount. Now, I am telling you this so you understand the law, not to suppress records requests. But I will tell you, just as a matter of good business, it makes zero sense to copy all the stuff, do the redactions, and then say, now you owe me, when a lot of times what will happen is they say, nah, never mind, I'm not going to write that check. And so do that part up front, okay? I don't need to go over with you the retention schedules, except to tell you that they're long. And if you need to know more about the retention schedules for given records, we'd have to go through what record we're talking about, what type of record it is. But there is a published retention schedule for records by the state of Florida, depending on the type of record, and your clerk should be able to get that for you at any time you need it, if it becomes an issue. Again, if you turned it over to the clerk, then they know, and they will handle it from there. So we're at 12:15. I'm supposed to go to 12:30. I'm looking through here. Oh, yeah. I love this slide. I tell you, I don't know John Hubbard, but I want to meet the man. There's a couple of things he put in here that I thought were very much worthy of covering, even though we only have a few minutes left, and I want to make sure there's plenty of questions. One is this incredible, wonderful life lesson. Merlot and email do not mix. So I'm a cab man myself, but the same thing applies, okay? It is not a good time to issue responses to constituents when you are deep into the wine or any other thing you might be into. And just think twice. What did your parents always said to you, or if you've been around any construction people, they say measure twice, cut once. Good advice. I want to talk to you too about meeting notes, and they really come into the same category as the Judas thing. When you are passing notes in a public forum, just like the fact of a communication that is in an open meeting situation, it's the nature of the communication that determines whether there's a violation. When you're passing notes, there's only one way to determine whether it's a public record, and that is to see it. So interestingly, to the point that I made earlier about the whole Judas note, the Judas note was not a public record. It did not perpetuate anything that was of a business nature or communicate. All it did, if anything, is say that one guy was mad at another guy. So I believe, although we never got to test it because the record was produced, that if the guy had said, I'm not going to give it to you, that would have been probably something that would have been upheld by a court. Of course, the guy who was on the receiving end of the note couldn't wait to give it to the news media, so that was a non-issue. But I point that out because it shows you that even if you're passing what would not qualify as public records, and I'll give you some examples, the public won't know that. And once the accusation is made, it's like putting the snake out of the can, the snakes that pop out. You can't, it's a lot easier to keep it in the can and keep the lid on it than it is to try to explain why it popped out. So how is that significant to you? Well, now the communication is by text. And I have literally gotten to a point where when I'm getting, this is what happens if you're the city attorney. You'll get text during meetings, so which tells me it's also happened to council members. I didn't even know the numbers. And you won't like what some of the things your constituents are texting me while I'm sitting there in your meetings. They're saying, can you believe so-and-so said that? With not much colorful language. Can you believe what a bunch of blank, et cetera, et cetera. And they think I'm their friend because I'm sitting there just trying to keep quiet, and they're irritated with whatever, and I become the target, and my cell phone number is on my business card and on my website and all that stuff. So and I didn't even know the numbers. They're just numbers. 727, I don't know who this is. And so even though I keep them, which they now understand as public record, I didn't even know where they came from. Somebody's going to have to go get a log to tell me who's sending me the stuff. But the point is that today, texts are the modern day note passing, but that doesn't mean note passing is completely out of order. During meetings, again, I know it doesn't happen with you guys. It just happens to me. But we'll have games, football games, World Series, National Championship football games, and so on, and people see her on the playground. I was really embarrassed when she read that one. And I still remember to her this day her name because of that note. So that's my best advice to you on meetings and notes. Now, another thing I get asked is about your personal notes. Let's suppose there's an issue that's coming before you that is significantly important to you so that you do, as I know some of you do frequently, your own research. Maybe it's about a vendor. Maybe it's about a zoning thing, and you want to know consistency of zoning in the area, whatever the issue may be. So you take a lot of notes. If you keep them to yourself and simply use them to help you get through the meeting and say, I've learned this and I've learned that, and you need to know this, this, and the other, but you don't pass out copies, those are still your notes. They are not public records. The moment you share them, they are public records. And that's the difference. So you're allowed to take personal notes, and that's important. particularly if you're interviewing constituents and you don't want to put in the record things that they might have told you exactly, but you need them to remember. But once that note, even if it's sent to only one council member, which as we already know shouldn't happen, but if it did, it becomes a public record.
Question.
Yes.
Can they be subpoenaed?
I'm sorry?
Can they be subpoenaed?
Absolutely. No public records
No,
exemption.
no, I'm talking about your notes.
That's what I'm telling you. I said absolutely. Because, let me explain to you what it takes to issue a subpoena. My signature. My meaning a lawyer. That's what it takes. You can object to the subpoena, and then you're going to have to convince a judge why I shouldn't get them, and I'm going to judge why I should. And if there's a matter that's involving litigation, for example, and it's not only whether it's relevant, but whether it could lead to the evidence that is admissible at a later date, I get them. Period. So everything I'm talking to you about public records is so the public can get them without having to go to court and subpoenas and all that stuff. But in a court proceeding, it's a whole different matter altogether. It's a different standard. It's all about what is the case about and whether it's relevant to that case. Yes, sir, and then I'll get you, yes, sir.
If I make notes in preparation for the meeting,
Mhm.
and at the end of the meeting, I keep them, they're still my personal.
They're still
notes.
your personal notes.
If I've made.
And because, let me stop you here, because they're your personal notes, if you were to destroy them then, you would not be violating anything. But if you keep them, to his point, and then when they were subpoenaed, you can't destroy them after they're subpoenaed.
But if those notes are, say, made on, the agenda item, and you leave your book, however your agenda's done, and then the clerk collects them.
It depends on what she does with them. If she, like I've left my bag, and if she says, hey, you left your bag, she can't go through and make everything in my bag public record. So it really does depend on how she handles them. Yes, ma'am.
No, I wanted to know too, if I made personal notes, if I could destroy them after the meeting.
Okay, well, I'm going to answer the question so the camera can hear. The question was, if you make personal notes for use during a meeting, can you destroy them after the meeting? If you have not provided them to any other living soul so that they then become a public record, then you have the ability, because they're your notes, to do with them what you would do with any other notes that are your own. Okay? All right. Now, this is another question that I wanted to cover with you, and that is something called the Schwab case. And this is becoming an issue. It's an issue in one of my cities, and it's becoming an issue because of the question of how far do the tentacles of public records and sunshine apply? Now, you may be scratching your head. What do you mean? We're all in government. We get that. Well, no, you really don't. Because I guarantee you that some of you, and maybe most of you, deal with nonprofits. We do in Ponce, as you know. I've got some of my Ponce folks up front and one out here. We have a nonprofit that runs a lighthouse. And I'm sure you all have nonprofits you deal with. So why am I talking about the Schwab case, and why is that important to you? It's important to you for the following reasons. When you're dealing with what you think to be a non-public entity that is a nonprofit, whether it be a lighthouse or something else, what is applied to the question of whether they are covered by sunshine or public records law is called the totality of factors test. And that test, as simply as I can state it in the time we have left, is there are about 8 factors, one of which is how much money do they get from the government versus their overall budget. One of which is, do they perform, even though they're a nonprofit, any essential functions of government? Are they in any way benefited by some asset that otherwise belongs to the city, like a long-term lease on a building that is otherwise the city's building, but they've been allowed to get a very favorable lease so they can run it and at not the expense of the city or the town or whatever, and a number of others. And nobody can stand at this podium, including me, and tell you when the scale has been tipped in favor of they are or they are not covered by public records and or sunshine, because it is an individual and case-by-case analysis. And why that's significant to you and how it can come up is that occasionally one of these nonprofits will be on the wrong side of somebody or some somebodies. And when that happens, they look for ammunition. And one of the tools in the arsenal of ammunition these days in this gotcha age is, well, they ought to be complying with sunshine, or they ought to be complying with public records. And then that issue is going to be squarely visited upon you as the public officials to figure out what to do. And it can have literally devastating effects on the agency or the nonprofit, both of them. Because, for example, remember those three words? Void, ab initio? If they've been violating sunshine, if you go through this totality of factors analysis and the opinion comes out against you, there could be an issue there. If they're not, you may be golden, but you don't know. So what you need to know and what you need to be able to communicate properly through your city attorneys, whomever they may be, is that when you're giving money to nonprofits, whomever they, or appropriating or budgeting, whatever term you wish to use, there are things that need to go to that analysis as to whether or not they are subject to public meetings and sunshine. Because if you have citizens then show up to their board meetings and they're turned away and they file a complaint, through the nonprofit, you're going to be embroiled in an issue. So you need to understand that. And that's called the Schwab case, SCHWAB, and the totality of factors. And you can find the discussion of the Schwab case in several AG opinions that are on the Attorney General website. And it'll walk you through some cases where they've been found to apply and the agency subject to, or the nonprofit subject to sunshine and public records, and cases where they're not. And it's an individual determination each time. So what are the penalties if you violate public records? $500 fine for non-criminal infraction. That's what's most typical, is the non-criminal. If you knowingly violate the provisions, it's the same as the others: suspension, removal from office, impeachment, or it's a misdemeanor in the first degree, potentially punishable by statute up to a year in prison and so forth. These are significant, and I would point out to you that as you go up the chain, what becomes most significant in these cases is the damage to your reputation and to your families and to your personal sense of sanity. It is a heavy toll, and it makes what you do difficult. It makes what you do sometimes not fun, but equally, it makes what you do vital to the system, because it won't work without you. That's all I've got formally. And I appreciate the opportunity. If you've got questions, I'm here for as long as I need to be.